Item 1 for motion.
My lord, page
Yes.
25.
Same question every case. Who is the father? Which one?
No, no. Page 25, 60.
Page 25.
Abdul Mateen, my father.
Page 25, Abdul Mateen.
My
66. What is the name of the village?
my lord, Devrail part block 3.
Sorry. Dev.
Devrail block 3.
Where is it written? Where do you get the name?
My lord, actually I bond that I have
Hmm.
in subsequent voter list it is written, my lord.
No, you cannot infer, but in
Right.
this one, where is it written?
It
Must
is
be Badorpur town,
Bodor
ward number
town,
2.
ward number
Badorpur town,
two.
ward number 2. Okay. And who is the petitioner? Fatima.
Fatim.
Which document will show? She
My
is the
lord,
daughter of
my name
Okay.
appeared with my father and page 31.
31. Is village Devrail and Badorpur town ward number 2 same?
Say within the village Devrail, within the ward number 2.
No, ward number 2 is a town.
Town.
It's a municipal town.
It is written
Village is a village.
Village. But
So how
Devrail,
a village is inside a town?
Right. that is actually Devrail, not village. It is a part of that town.
What about page 33? That the entries in the marriage register.
My
Entries in the marriage register, page 33.
Yes, Lordship.
Fatima Begum, daughter of the village Devrail, post office and so. Heard Mr. Only thing they will verify whether Devrail and Badorpur ward number 2 are one and the same. Heard Mr. Ann Hawk, counsel for the petition. So heard. The petitioner Fatima Begum had been referred to the foreigners tribunal number
1.
foreigners
Yes.
tribunal number 1, Karimganj, for rendering an opinion as to whether she is the person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 674/2012. The tribunal rendered an opinion dated 29/7/2016 that the petitioner is a foreigner. Being aggrieved, district petition is instituted. In the proceeding, the petitioner relies upon the voters list of 1966 of Badorpur town ward number 2 under police station Badorpur in the district Karimganj, which contains the name of A. Mutin, son of Javed Ali at serial 1497. Petitioner also relies upon the copy of the entries of the register of marriage under section 11, 14 or 21 of what act? These sections. Nothing is written. So in the origin also nothing is written. Marriage stop section which contains the name of the bride to be Musammat Fatima Begum, daughter of late Abdul Mateen of village Devrail, post office and police station Badorpur district Karimganj. Accordingly, the petitioner claims that she is the daughter of Abdul Mateen of the voters list of 1966 of Badorpur town ward number 2. In view of the above, matter remanded back to the tribunal to examine as to whether Abdul Mateen of village Devrail, PNO, post office and police station Badorpur, as per the entry in the register of marriage, and A. Mateen, son of Javed Ali of the voters list of 1966 of Badorpur town ward number 2 under serial number 1497 are one and the same person, and also as to whether Badorpur town ward number 2 and village Devrail are also the same place. Upon examining the same, it is in order to be passed.
Item 2 for admission. May it please your lordship, my senior the commissioner, she is gravely ill and the doctor have advised her to take bed rest.
Yes, Mr. Chaudhary, Mr. Bharat.
Lordship, some samples have been taken and Lordship will finding that there is a child. Lordship, residues were found, pesticides, but they were within the limit. And in case of those,
So everything is within limit, nothing is beyond limit.
no,
Only thing the kidneys and the organs of
Yes.
the citizens are beyond the limit.
Lordship, and with regard to the pesticide residue that was that the report that I gave on last occasion, Lordship, those were in regard to those found in the agriculture field. And those are yet, I have been informed, Lordship, in the spraying, it takes some waiting period, time is there.
Mr. Motin, the lady before, Madam Ghosh, one on your right. Your mobile phone, that thing is on, light, it's disturbing us. No, not that light. I think so. Yeah, yes,
Lordship, with regard to the residue that was in the report that I gave.
so you mean to say nothing is happening?
Lordship, residue.
Because we have some newspaper reports, we have some information that after our order, things are happening more. Nothing is taken care of.
Lordship, in that regard, Lordship,
See, some further inquiry may be ordered against your officials also. Take note of it, Mr. Chaudhary, act accordingly. Next week.
Lordship, there is a issue has arisen, Lordship. Under the Food Safety Act, the Commissioner of Food and Staff is the nodal agency. Lordship, the Agriculture Department is trying to move everything in very fast speed, Lordship. But there is some lack of coordination
Between?
with the Lordship, Commissioner of Food Safety and
Who appears for the Commissioner of Food Safety?
Lordship, if Lordship, some directions are there.
Ask him to remain present. The Commissioner and Food Safety Government of Assam to remain present on the next returnable date, response so and so. You make the submission on the next date, Mr. Chaudhary.
Lordship, because we are on the in our earlier report, we have stated, Lordship, we have constituted
Understand.
six groups.
You make this submission on the next day. Ask him to remain present. Do you represent him?
In this case, my lord, I can.
Ask him to remain present.
Get like this.
If the Agriculture Department is saying there is lack of coordination, if nothing happens, next Chief Secretary has to remain present.
Well,
If the coordination is not coming between different departments, we'll
Was
ask
it-
that Commissioner, why is it so?
the first
if-
time.
If he is not cooperative, Chief Secretary, if not further, some further higher.
First time it has come to our knowledge.
Lordship, because
And our report from the ground is nothing is happening. Yes, next item.
Lordship, because on interaction, I could make it out that Lordship, there is lack of coordination.
Yes,
Lordship.
we'll try to bring in coordination. If not possible, we'll think what is to be done.
Yes, Lord.
That's a copy of the order.
Copy of the order, Mr. R.K. Bora. Next Tuesday. And if no one is cooperating, mind you,
Yes,
we are
yes,
going to
yes,
take
yes.
action against your senior most officials.
Yes.
They are also not above the law.
As you know,
Yes.
And Lordship,
we inform accordingly.
Lordship, being a law officer, Lordship of this code, Lordship, I have to inform. I've come across a PIL being is also there in the Supreme Court, where Lordship, this S.K. Khurana, who was earlier heading this committee, he has submitted some report and those were being called for, Lordship. I'm trying to get it.
You can get it also.
That
It will be helpful.
Yes, Lordship.
But what we have noticed, there is no substantial difference.
Yes.
And we can take judicial notice of that also. Means somebody is trying to overreach the court orders, nothing else.
4th April. Next
And who
Tuesday.
are these people manning the gates?
Lordship, person from agriculture.
They are doing their work or they are not doing their work?
Yes, they are doing, and they have.
Then who is not doing the work?
Lordship, with regard to mobile van for taking the testing, the food safety and drug administration commissioner.
Give us the statistical data of the last 15 days, what has been done. How many has been tested, what has been detected, and what you have done with it?
Lordship, they have given me the report of each and every item.
Every day.
Chart. Yeah,
Every days, how many were tested, how many were put up across the barriers in the entry to Guwahati? What is the result of the test and what has been done?
Yes, Lord.
Complete detail.
And how many
Complete detail of the testing that has been stated to have been done, be also provided on the next returnable date. As regards the data of the data on and from 1/3/2023.
And then how many partial presence in the, my lord?
Everything
Second point, yes.
completed.
Yes.
Let's see what we have done.
Item 3.
Yes.
Your lordship. In this case, lordship, petitioner's father's name appeared in the voter list of 1970, lordship.
Page number
Page number, lordship, 37.
37. Kudrat Ali,
Kudrat is my father, lordship.
father. Which document will show Kudrat is the father?
In page, lordship, 43.
Sorry,
My name appeared with my father in page 43, lordship.
what page?
Page 43.
43.
A. Jalil. Abdul Jalil. My name is Abdul Jalil.
Second one also.
And Jamabundi also.
Third, Mr. Suleiman, then counsel for petitioner also.
Jamabundi.
The petitioner Abdul Jalil had been referred to the Foreigners Tribunal number 2, Nagaon, for rendering an opinion as to whether he is a citizen of, whether he is a person who entered the state of Assam from the specified territory on or after 25/3/1971, resulting in registration of FT case number 1785/2011. An opinion dated 2/5/2018 had been rendered declaring the petitioner to be a foreigner. In the writ proceeding, the petitioner relies upon the voters list of 1970 of village Amlokhi, police station Dhing in the Nagaon district, which contains the name of Kudrat Ali, son of Yasin, at serial 1158, and that of Ramisa Khatun, wife of Kudrat, at serial 1155, both residing in the same house number 109. The police station also relies upon the voters list of 1997 of village Amlokhi, which contains the name of Kudrat Ali, son of Yasin, at serial 991, and that of Ramija Khatun, wife of Kudrat Ali, at serial 992, and A. Jalil, son of Kudrat Ali, at serial 993, and all three are shown to be residing in the same house number 276. Full stop. The aforesaid information is correct. may prima facie lead to a conclusion that the petitioner is citizen of India. In the circumstance, matter remanded back to the tribunal to examine the voters list of 1970 and 1997 of village Amlokhi, which contains the name of Kudrat Ali and A. Jalil, by showing him to be son of Kudrat Ali in the same voters list. The state respondents to also verify as to whether A. Jalil of son of Kudrat of the voters list of 1997 and the Kudrat Ali, who is the writ petitioner before this court, are one and the same person. Upon the examination, reason order be passed.
Like this.
Item 4,
And if necessary, by visiting the house of Kudrat Ali and A. Jalil. Rosteri है लगे एवर्टरी खुला नहीं एवर्टरी yes Abdul Hussain Borbuya.
Yes, Lordship. Lordship, my father's name is, petitioner's father's name is Babur Ali.
Page number
Page 127, Lordship.
page 120.
127, 127.
Mhm. Babar Ali,
Yes,
son of Montesri Ali.
Sorry.
And
Monteshwar.
which document will show? Who is
Yes,
the
Lordship.
father?
My name of my father, mother and
What's the
grandmother,
name of the village? Bhajantipur.
Bajantipur.
From Gandhi. Which document will show that Babar Ali is the father?
Yes, Lordship. Page 141, Lordship. Mother's name appeared in the year 1966 along with the father of the petitioner, Lordship.
No, it's okay. What's the name of the petitioner? Abdul,
Abul Hussain Barbuya, serial number
Abdul.
123, Lordship.
123. Moriam Bibi to us. Heard MS H. Betalal and counsel for the petitioner. Abul Hussain Borbuya had been referred to the Foreigners Tribunal number
Four,
4, Hailakandi, for rendering an
Lordship.
opinion. Huh?
Kamrup Metro. Kamrup Metro.
Kamrup Metro, not Hailakandi. 4 Kamrup Metro for rendering an opinion as to whether he is a citizen. Same. Resulting in registration of case number
Case number 1654
1654
of 17,
2017. An opinion dated
39, 2019.
39 2019 had been rendered declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ petition, the petitioner relies upon the voters list of 1966 of village Bhajantipur, first part, under police station Hailakandi in the present Hailakandi district, which contains the name of Babar Ali, son of Montesri Ali, at serial 226, and that of Moiran Bibi, wife of Babar Ali, at serial 228, and both are shown to be residing in the same household, house number 71. Petitioner also relies on the voters list of the year 2005 of village Bhajantipur, first part, which contains the name of Mariam Bibi Bewa, wife of late Babar Ali, at serial 118, and that of Abul Hassan, what is that for a Borbuya?
Yes,
Borbuya, son of Babar Ali, at serial 123, and both Mariam Bibi and Babar Hussain Borbuya are shown to be residing in the same house number 45. We have noticed that the name of Mariam Bibi appeared along with Babar Ali in the list of 66 and also along with Abul Hussain Borbuya in the list of 2005. In view of the above, remanded back to tribunal for examining as to whether the voters list of 1966 and the voters list of 2005 of village Bhajantipur Part 1 shows that the petitioner is a citizen of India. Keep your read last sentence. And according to pass a regional order thereon, the state respondents to also verify as to whether the Babul Hussain Borhuia of the voters list of 2005 and the Babul Hussain Borhuia, who is the writ petitioner proceeding, are one and the same person, if necessary, by visiting the house number 45 of village Bhajantipur Part 1. Region order is this same. The petitioners to produce the complete voters list between 1966 and 2005 of the before the proceedings, before the tribunal.
Next, well, with the, along with the writ petition launch.
But writ petition will remain here.
Already submitted there also. Lord.
Writ petition will remain here.
Yes, Lordship. Therein, we have filed the review before the honorable.
Do everything but produce it.
Yes, Macho.
Item 5,
Yes, Madam Devi. Sara Bhanu Bibi, who is the father?
Father's name is, my lord, Ishab Ali.
Page
There
number?
are several names, my lord. And grandfather's name is Farid Ali. And
And out of the several names, who is the person before us, or all of them?
no, my lord, no, one person has several names. my
That's why I'm saying, who is before us?
lord. The father, Ishab Ali.
Father
said.
is before us.
No, Sarbanu Bibi, father,
Which page is the father?
66, their name is
Page
shown,
number?
father's,
Page number.
page 29.
Farid Sheikh.
Farid Sheikh,
Garamari village.
yes. District Gwalpara, Thuburi,
Farid Sheikh,
Garamari part 3.
And who is
Then
the?
Ishab Ali's name is shown,
And Isob Ali is the,
70,
Farid Sheikh is the grandfather.
grandfather, Farid Sheikh.
And who is the father?
Father Ishab Ali, his
Page
name
number?
is shown in 70s, my lord.
1970 voters list.
Yes,
Oh.
Farid Sheikh, Ishab Ali, yes, my lord. What did that, no? Number? Ishab Ali, my lord, page 31. Father's name is Farid Sheikh. Ishab Ali's,
Now,
Daughter comes.
now which document will show
my lord,
that Sara Bhanu is the daughter of Isob Ali?
Sarabanu's another name is my lord. Her name is shown in the, my lord. Khattian, my lord. But it is shown as Sarabanu Khatun.
Khatun is okay, Khatun and Bibi.
Yes.
That where, which page number?
Page is 38, my lord.
38, it's a Khatian.
Khattian. Lenin position of right. Her name is shown as Sarabanu Khatun. Page 38. Translation. In Assamese to আছে কৰিবই নোৱাৰে. And she got married with one, my lord, Fakir's son, my lord. But
Actually, you are a riot.
right,
Riot. Name of the riot's father's name.
rioter Kissa
Where is the father's name? Son of Ishab Ali.
Ishab Ali. They
And-
are daughters of the Ishab Ali. Say,
All three are daughters.
all three are daughters, but her name is shown as Sarabanu Khatun. And after marriage, my lord, her name as soon as
Sarabanu
Sarabanu
Bibi.
Bibi.
Definitely, after marriage, a person can be
Yes, yes,
Bibi.
my lord.
How can a person be a Bibi before marriage? So this is not,
This is my
but
case,
this is of which village? Garamari. Yes, Mr. Sharma. যাও করি। Third, কিন্তু মোটা হচ্ছে।
Kabinama was also not examined that, no? Kabinama cannot থাকিব.
Heard Ms. MSK Devi, land counsel for the
Women for
petitioner,
it.
also heard এই হিলিপুর মাটি বড় আর ওই চৌধুরী মাটি দেখতে Sarabanu Bibi had been referred to the Foreigners Tribunal number
Number
hmm,
4. Space and 30.
Foreigners Tribunal number 4 Dhubri for rendering an opinion as to whether FT case number 4/GPR/108/2017. An opinion dated
Dated 23/5/2019.
23/5/2019 had been rendered declaring to be being aggrieved this writ petition is instituted. In the writ proceeding, the petitioner relies on the voters list of 1966 of village Garamari stroke 101 Garamari Part 2 under police station Dhubri in the present Dhubri district, which contains the name of Farid Sheikh, son of Dhuturu Munshi at serial 5, and also that of Yusuf Ali, son of Farid, in the voters list of 1970 of village 101 Garamari Part 2 at serial 630. The petitioner thereafter refers to a Rayati Khatian in respect of a land in village Garamari Part 2, wherein the name of the riot, father's name and place of dwelling is shown to be Sarabanu Khatun, along with Nurbanu Khatun and Nur Khatun, all being daughters of Isab Ali Sheikh. In view of the matter remanded back to it for examining the voters list of 1966 and 1970 of village Garamari, 101 Garamari Part 2 stroke Garamari, as well as the Rayati Khatian in respect of a plot of land in village Garamari Part 2, which amongst others contains the name of Sarabanu Khatun, daughter of Isab Ali Sheikh.
Kabil naman, no?
Full stop. It is stated that, it is clarified that Sarabanu Khatun, after her marriage, is now known as Sarabanu Bibi. Full stop. After that, to
Kabil
pass a
naman is not
reason order, full stop. And if the state respondents to also make a verification as to Sarabanu Khatun, daughter of Isab Ali, as contained in the Rayati Khatian, which reference to the voters list of 1966 and 1970 village Garamari, and the proceedee Sarabanu Khatu are one and the same person.
Kabil naman also not examined. Kabil.
Petitioner may produce any other relevant material.
Yes, madam.
Item 6 for hearing.
Yes, so this Upendra Majumdar, who is the father?
My lord, page 14, my lord, still did my lord, in the name of Nandolal. Nandolal Majumdar is my father.
14,
14. My lord. Page 14 is is a cell deed, my lord.
Nandalal Majumdar, he is the father.
Yes, my lord.
Which document will show he is the father?
My lord, another cell deed, my lord, in the name of my lord petitioner, that is page 21, my lord. Can you see? Processors Benudhar, Onil Chandra Mazumdar, Nitin Mazumdar, and Upen Chandra Mazumdar. They are the brothers, my lord.
Mr. Chaudhary and Mr. Bora? Mr. Chaudhary and Mr. Bora? Take note of this news item and submit a report on the authenticity of this news report.
Yes.
we are not passing any order. A report both by the Agriculture Department as well as which is the other department,
Commissioner who
Home and Health, to submit a report on the authenticity of this news item. You make an inquiry whether this is right or wrong. Yes, page 10,
Page
20,
yes, my lord. Page 21, my lord.
21.
My lord, Benudhar Mazumdar, Onil Mazumdar.
And this newspaper will keeping on record.
yes. I'll return. it.
Sorry, page 14, Nandalal is the purchaser now.
Yes, my lord. Nandalal Mazumdar is my father, my lord.
Hmm.
My 21, page 21, my lord.
Upendra,
Upendra
all are son of
Mazumdar.
Nandalal.
Yes, my lord. Son of
Payamari.
Nandalal Mazumdar. That is, my lord, sold it 1970, my lord. And petitioner also, my lord, was a railway employee who got retired in the year 2012, my lord.
No, no, if you are there in 1970 to purchase land,
Yes, my lord.
you on your own is not a person who entered after 71.
Yes, my lord. These documents also exhibited, my lord.
70 if he purchased land, how can he enter after 71? Yes. If the man purchased land in 1970,
Yes,
how can he enter after 71?
Yes, okay.
Mhm.
Okay. Reference will say, Lord. Reference.
Please take a look at reference to DDO. लगे बोले.
Also, my lord, a railway employee, my lord.
Railway employee working in the army, this will not make you any citizen. You will be citizen only through the relevant materials.
Yes.
Third, Mr.
Yes, sir.
A. Hussain and counsel for the petition also. The petitioner, petitioner Upendra Mazumdar, alias Upendra Chandra Mazumdar, had been referred to the Foreigners Tribunal number
My lord, Foreign Tribunal, Kokrasa.
Forest Tribunal at Kokrajhar for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number K/FT/538/2006. The tribunal rendered an opinion dated 14/8/2017 that the petitioner is a foreigner. Being aggrieved, district petition is instituted. The petitioner relies upon a sale deed dated 8/10/1958. A registered sale deed dated so and so, by which Nandalal Mazumdar, son of late Ramachandra Mazumdar, resident of village Tokiamari, police station Gosaigaon in the Kokrajhar district, had purchased a plot of land. Full stop. Petitioner also relies upon a sale deed dated 1/9/19, registered sale deed 1/9/1970, by which, along with Benudhar Mazumdar, Anil Chandra Mazumdar, Nipendra Mazumdar, Upen Chandra Mazumdar, all being sons of late Nandalal Mazumdar, purchased a plot of land at purchased a plot of land at village Tokiamari, police station Gosaigaon in the Kokrajhar district. It is stated that the two sale deeds are exhibited before the tribunal. The sale deed dated 1/9/1970, by which Upendra Chandra Mazumdar, son of Nandalal Mazumdar, resident of village Tokiamari, had purchased a plot of land, is by itself an indication that Upendra Chandra Mazumdar cannot be a person who had entered the state of Assam on or after 25/3/1971 until and unless it is the stand of the state respondents that Upendra Chandra Majumdar, after purchasing the land, had again went back to the specified territory and thereafter re-entered to be declared to be illegal migrant. No such material is available. Consequently, Upendra Chandra Majumdar, son of late Nandalal Majumdar, resident of village Tokiamari, police station Gosaigao of Dhubi district, is declared to be an Indian citizen. He shall be entitled to all rights and liberties as may be entitled under the law.
Item 7.
May it please your lordship.
Ayub Ali, who is the father?
My lord, Sulman Ali, my lord. Name, my lord, your lordship will turn to page,
The page number
page 14, my lord.
14. So Sarvan Ali,
Surman Ali, my lord,
Surman Ali, yes, Surman Ali,
197.
son of Damulla.
Damullah. Now your lordship will turn to page 15, 1977.
Page 15, 15.
Yes. Surman Ali. Son of Damullah. Now, my lord, your lordship will turn to page 19. Whole family, my lord, at page 20.
Page 20.
Surman Ali, Damullah, my lord, Hafiza Khatun, Surman, Hafizur Rahman,
Now, who is
Surman,
the petitioner?
my lord. Petitioner is Ayub Ali.
Ayub Ali.
So, my lord, Ayub Ali educational document is there, my lord, to link with Surman. Your lordship will turn to page 21. My lord. Page 21. Registration card, Board of Secondary Education, Surman Ali, Hafiza Khatun, Ayub Ali.
Mr. Sheikh, you do one thing. We are sending it back
My lord.
because this Seva people cannot be brought to the tribunal for giving any evidence.
My
It
lord.
will be a little far-fetched.
My lord.
You take a certificate from the school where you had read
My lord.
and produce the headmaster with the school records. I think that will serve your purpose.
My lord.
Heard Mr. M. A. Sheikh and counsel for the petitioner also. Ayub Ali alias Muhammad Ayub Ali alias Muhammad Ayub Ali, due to Ayub spelling the leg, is referred to the Foreigners Tribunal Jorhat for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971.
Here is full certificate.
Resulting in registration of case number JFT 201/2014. The tribunal rendered an opinion dated 13/10/2017 that the petitioner is a foreigner. That school certificate is there, Mr.
yes,
Sheikh,
sir,
page 22. The petitioner being agreed, the petitioner relies upon the voters list of 1970 of village Bagmara Chor Nongke, police station Bagwar in the Borpeta district, which contains the name of Surman Ali, son of Damulla at serial 197. Petitioner also refers to the voters list of 2016 of village Bagmara Char Nongke, which contains the name of Surman Ali, son of Damulla at serial 594, and that of Hafiza Khatun, wife of Surman at serial 595. The petitioner thereupon relies upon the registration card issued by the Board of Secondary Education Assam, containing the information that Ayub Ali is the son of Surman Ali and Hafiza Khatun, and the name of the school is Bagmara Char High School. The petitioner also relies upon the
Mark sheet.
Certificate issued by the Bagmara Char High School, which contains the information that Ayub Ali is the son of Surman Ali of village Bagmara Char. So the matter remanded back to the tribunal to enable the petitioner to examine the headmaster of Bagmara Char High School, who may depose before the tribunal along with the original admission register of the school, which may contain the information that Ayub Ali is the son of Surman Ali of village Bagmara Char. The petitioner to also produce all the complete voters list from 1970 to the year 2016 in respect of village Bagmara Char for the examination of the tribunal. The respondents in the Home Department may make a verification as to whether the proceedee Ayub Ali and the Ayub Ali, son of Surman Ali of village Bagmara, with reference to the school certificate, as well as the aforesaid voters list, are one and the same person.
Let impugn order will be set aside or.
We passing the same order. Last paragraph, I am not dictating because it's a common paragraph in every paragraph.
Item 8,
Appearance date will be given.
8 May.
Everything is there.
My lord, 8 may be taken after vacation. Because my lord,
Item 8.
I have some problem with this.
Acha, 8 after this. I don't know the prayer of Mr. Amachik and conversation.
Item 9.
Item 9, yes.
When we file the application, we don't have the document.
Amina Khatun, who is the father?
Father is Jafar Ali, my lord.
Page number.
Look, problem was that I could not annex those things, but,
You file an affidavit. Mr. Dasu, seek for adjournment to file some further documents.
no, I have brought this certified copies of this
So
document.
file it, bring it on record.
Yes.
File an affidavit
Yes.
and include those documents.
The certified copies of that. Now, when we file those documents,
List after 2 weeks.
let it be after a month, Lord. My junior is at somewhere else.
List after a month.
Item 10.
Mr. Dasgupta, 1 or 2 documents, loose document we are accepting. But we have noticed this petition does not contain almost any material.
No, that is
Everything
why I
will
brought
be
the
in addition. So
certified
therefore,
copy.
file an affidavit. Yes, next item, please.
I brought the certified copies
Yes, Mr.
from
Thakur.
the tribunal. Yeah, please, no, my lord. This is the. This is.
Yes, who is the father of Nur Muhammad?
My lord, Nur Muhammad father is Jalaluddin.
Page number,
My lord, the school certificate is there, my lord.
page number.
My lord, page number is 23. 24 Barnacular.
Satyameva Jayate, headmaster. Hmm. So খালি হাতেরও ভরাই দিলেই হলো। Yes. Petitioner is Muhammad Sheikh, son of Jalaluddin, village Hasdo, Tritiyo Khondo. Yes. Which document will show Jalaluddin is a citizen?
My lord, 1997 voter list is there.
Page number.
But my lord, 1997 voter list, by that time, it was not issued. There was some defect in the office. So that is why we did not furnish unless it is certified copy.
Mr. Talukdar, who is asking you so much of explanation?
Yes.
Which document will show that Jalaluddin is a citizen? First, show us
My
that.
lord, in the LCR Annexure 4, page 31, my lord.
LCR, page 39,
31, my lord.
31. Yes.
165, my lord. So he is the father of Nur Mohammad Sheikh, my lord.
Mr. I. A. Talukdar, Land Counsel for the petitioner, refers to a school certificate issued by the headmaster of 1666 number Borua Vita Basiruddin LP School, which contains the information that Nur Muhammad Sheikh is the son of Jalaluddin of village Kismat Hasda, third part. Petitioner thereupon relies on the voters list of 1997 of village
Same village, my lord.
Mr. Ali. Where is he? Come to page 31 of this writ petition.
31 is not here, Lord.
LCR.
LCR.
LCR, sorry.
Jalaluddin. Village, same village.
No, Jalaluddin is okay, 165, no difficulty with that. Is this an authentic voters list? Because everything is printed,
This is
Then-
Panchayat Nirbachan, Lord.
whatever it is, the names of the people are printed,
Yes,
but the name of the village is handwritten.
yes, Lord.
Why the election department, if they take out a voters list, will not print even the name of the village?
Yes, because I'll have to come.
If they are ready to print the name of the people,
Yes, Your Lordship, because
the Mr. A. Ali, Land Counsel for the petitioner to obtain the information of election
Yes,
department
Lordship.
with whether
I
the,
submit, Your Lordship. For Panchayat, Your Lordship, Assam State Election Commission appears, Your Lordship, because it is their custody, these documents are in their custody, Your Lordship. Panchayat electoral roll, Your Lordship.
so
Rakesh Dubey-
election commission does not have this voters list?
No, Your Lordship, we have.
Is there a separate voters list between Panchayat,
Yes, sir.
Assam?
Yes, Your Lordship. Panchayat municipal, that election.
So some people can vote in Panchayat, but they cannot vote in the,
But this
other ele-
voters have to verify, Your Lordship.
you verify whether this,
I'll
verify whether the voters list at page 31 of the records
coordinate with them.
is an authentic voters list after 2 weeks.
If I can obtain a
This
copy of-
may be a printout taken out by the Panchayat department.
Yes.
But the list, corresponding list also has to be there with the
The
election commission. Otherwise, Panchayat department do not maintain a separate voters list.
In the election branch, it will be there, Your Lordship. I will
Please
coordinate with
check
them.
up.
I can take a copy, Your Lordship. from them.
And secondly, why Panchayat writes the name of the village by hand,
So because it should not be, Your Lordship, because
But
it should be
they-
printed, Your Lordship.
but even the name of the voters are printed.
Yes, Your Lordship.
What prevented them from printing the name of the village?
Once you obtain the complete voter list of Your Lordship, then we can see.
Just see what it is
I'll obtain it.
after 2 weeks.
I can obtain, if Your Lordship permits me to obtain a copy of this voter list for Xerox files.
I can take a photocopy of
Yes.
this. Mr. Ali,
You can take from me.
Oh.
I can help you.
Oh, yes.
yes, next item.
Item 11.
Yes, item 11. Then appears for a petition of when the matter is called, list again on subsequent non-appearance, adverse order shall follow.
Item 12.
Same order.
Item 13.
13, Lordship, I raised for some time, Lordship.
Adjourn on the prayer of Mr. G. Sharma, Land Counsel for the Home Department.
2 weeks. For orders, item 20.
Page 9, my lord.
I for what?
My lord,
Why is you filed an I?
my lord, two small correction, my lord.
Correction,
Yes, my lord.
page number,
Page 9, my lord.
page 9.
Page 9, 6 line, my lord. Here is superintendent of Moregaon, that should be
Page 9, 6 line
Golpara.
Should
Golpara.
be Gwalpara.
And
Third, Mr. A. Motilal comes up
lordship,
with-
another, my lord, page
One more.
10, my lord. Page 10, para 3, second line.
No, just a minute,
There is Katari Hara. Katari Hara Madrasa. my
no, no, you're referring to page 9. Where is Gwalpara?
Yes, my lord, here is page 9,
I think it must be
6 line, my lord, superintendent of Moregaon, that should be Gwalpara.
page 9.
Page 9, my lord.
Huh. Sixth line.
6 line.
Okay, this one. Huh. Huh. Okay,
Yeah.
and after that?
After that, page 10, my lord,
Hmm.
second line. First line, the petitioner claimed that Zafaruddin Sheikh, son of Sabed Ali Sheikh of village Katarihara, is not Katarihara, Posim Kathari, my lord. Katarihara Madrasa, my lord.
Acha, of village Katarihara, it should be Poschim.
Yes, Posim Kathuri.
This is the only change.
Yes,
Any more?
yes, yes, that is my lord. And here is also my lord, line number 4. Fourth line,
Of,
village Katarihara, it should be.
we have taken note of that.
Yes,
Katarihara and Morigaon.
Posim Kathuri.
Third, Mr. This I 881/2023 is instituted for incorporating certain correction in the order dated 21/2/2023 in WBC 1356/2017. In paragraph 1 of the said order, it be read as Superintendent of Police Border B Morigaon, be read as Gwalpara.
Golpara.
Gwalpara instead of Superintendent of Police bracket B Morigaon. In paragraph 3, in the fourth line, village Katarihara be read as village Poschim Katarihara.
Kathuri.
Kathuri,
Kathuri.
village Poschim Kathuri.
It's a second line also, my lord. Second and fourth.
Where?
Page 10.
In in the second and fourth line, the village Katarihara be read as village Poschim
Kathuri.
Kathuri. Any more? No.
No.
I allow subject to
Obvious.
the aforesaid change.
My lord, tomorrow is the APR date, my lord, as per this order.
As the correction is required in the order, the appearance date be now
10 days, my lord, or 5 days.
the petitioner to now appear before the tribunal on
12 April.
Obvious.
Item 14 to 19.
This judgment of Khudiram, few paragraphs I would like to underline.
Chagma.
My lord.
Itu dia naik ni, Kuriam tu dia naik.
1994 supply 1 SCC 615.
Refers to Khudiram Chakran.
My lord.
Khudiram.
My lord, in this case, although I'll be ultimately relying on the observations made by the Honorable Supreme Court in paragraph 75, 76, 77, and 78. But in first few paragraphs, in order to, my lord, will be necessary in order to show in what context these observations were made.
This one is interesting. That page 631,
My lord,
that quote of Warwick Mackin.
my lord. And if your lordship,
Equality and discrimination under international law.
my lord. And
Once lawfully admitted to a territory, they are entitled to certain minimum rights necessary to the enjoyment of private life. That is, it is preceded by once lawfully admitted.
my lord. Yes,
And,
that is why when I,
and before that,
yeah. In fact, they
states
were,
have traditionally reserved the right to expel them from their refuge when they are. Then certain rights which are enjoyed by their own national, that is. Right to vote, hold public office, engage in political activity. Aliens may be prohibited from joining civil service or other certain or from owning some categories of property. States will place them under restrictions in the interest of national security. Okay,
but
so now these categories of people, are they admitted?
No.
If they are admitted. Nevertheless, once lawfully admitted,
yes,
once lawfully admitted may be those category of people by virtue of this. Some accord or the other
Yes.
instruments. Having given the acceptability of a citizen up to a particular period. That category may be lawfully admitted,
yes,
but subsequent to that. Can we say they are lawfully admitted, although they are staying for a long period of time?
now, I, basically, my submission will be, when if we go to the background of this case. Initially, they were even given allotted land. So initial entry was lawful,
No, we are not looking at this judgment from the Chakma point of view.
my lord, yes,
Because Chakmas are a little differently situated.
yes,
There are some materials which may indicate that they are lawfully.
yes, yes,
Although. Under what status, that is not very clear. We are. Basically on this court,
yes,
which Supreme Court has possibly accepted to be the law.
yes. Para 78, lordship is saying para 78,
194 of the book by Warwick Mackin.
yes,
This shows the
yes. For that
maximum clue as to what is the,
extent of right they can exercise,
what is the position of international law as regards this one.
yes, yes. Para 75 also quoting that Louis D. Rate. It is true that fundamental right is available to a foreigner as held in so and so. Then para 13 of Louis D. Rate was quoted. Then the observation is,
If the person is not lawfully admitted. The right to vote should not be there. Right to hold public office or engage in political activity should not be there.
my,
Also, they may be prohibited from joining civil service or certain professions. And state may place them under restriction in the interest of national security or public order as regard some category. And also as regard some category of properties.
yes,
Something will be allowed, something may not be allowed.
my. And it says, well, nevertheless, once lawfully admitted to a territory, they are entitled to certain minimum rights.
Minimum rights. That
Minimum.
is also not every.
No, minimum.
Minimum rights, whatever the
Right
state
to
wants to. give
food
them, the state
during the
will give
period
it.
he is there, food minimum, food is necessary for survival of a human being. man.
So till lawfully admitted, even that is not there.
Enjoyment of ordinary private life.
Enjoyment of ordinary private life. Food is not an enjoyment of ordinary private life. Food is a necessity.
Survival.
You can't do that. Who will explain that, the central government or the state government? Regarding the, in what manner the right to food will be provided?
Well, for that, my lord, possibly, my lord,
One is section that CC or the
CC,
Foreigners Act.
yes.
3(1)(c)(c). That they had to bear their own costs.
my lord.
But bearing the own cost for everybody, it may not be possible.
My lord,
Considering the nature of these people,
My
the state of these people. For everybody, it may not be possible. To make it possible, we will have to allow them to work.
my lord, there, but possibly, well, I would like to rely on one judgment. A recent judgment of Karnataka High Court, my lord. AIR 2022, Karnataka, we. I think AIR 22, Karnataka, page 43. Lee Dong versus Union of India. As a few paragraphs of this will be quite relevant. Man. I'm reading from paragraph 1 itself, man, of the judgment. Petitioner, a national of People's Republic of China, is once again knocking at the doors of writ courts seeking an appropriate order that would facilitate the extension of her stay.
Mr.
My-
Read the next paragraph of the.
Which, para, my lord,
The
next page,
the next page.
Chakma, yes, yes, yes.
Read the next page.
General international law, my lord.
Ah.
General international law provides that aliens should
not be discriminated
against
enjoyment of property rights.
once they have been acquired. Here,
This
here-
is acquired by legitimate means acquired by. not
Yes,
legitimate. This distinction has to be.
yes,
Then read further.
yes,
If
E-
alien property is nationalized, whereas the property of nationals remain unaffected, then act is discriminated,
my lord.
prohibited under international law.
As Fitzmaurice points out,
Fitzmaurice points out, it has long been recognized that in certain matters, that is the general treatment of foreigners in the country or compensation for property which may be expropriated or nationalized, non-discrimination as between persons of different nationality or against foreigners as compared with persons of local nationality amounts to rule of international law, the breach of which gives rise to a valid claim on the part of the foreign government whose national is involved.
these objections
Yes,
came,
Mr. Mr. Raman. Even if it is done, it will be a breach which will give rise to a valid claim on the part of the foreign government whose nationality.
My lord.
Suppose this property is appropriated by the government of India, provided it is legitimately acquired and subject to other laws, we'll see to it. Then it may be called discriminatory. But the remedy provided under international law is it will give rise to a valid claim on the part of the foreign government, that is the government of Bangladesh, whose nationals are involved. So again, you are in a catch-22 situation. The government of Bangladesh then has to recognize that these people are their citizens. So once it is recognized, Mr. Mojumdar, you can take up.
for deportation, it will be easy. Man. It will be of some help. One clue, my lord.
My lord, the problem will be solved if they can be deported.
Yes.
In that case, the.
Problem will be solved if the other country accepts them to be their
This is-
citizens. They are not.
That's a.
This
condition
is what
precedent.
Mr. Rakesh Chaudhary is submitting.
My lord.
Bangladesh is not accepting. This is where the roadblock has come.
They will be here indefinitely.
No, it's up to them. It's up to them. They're free people.
My lord.
Neither the court nor the government of India is holding back them in any manner. They are free people. They came by their own freedom. It's up to them what they want to do. We are only deciding as long as you are here, what you'll be entitled and what you are not entitled.
The last few days, I have submitted before your lordship about these basic rights, the right to food, right to livelihood.
I think we have heard
My
you
lord,
number of days on the same repeated things.
my lord.
Why do you want to bring it again today? If you want to submit further, please do it. You are most welcome. But repeating the same sentences every day will
My
not make it something stronger.
My apology.
See, if 2 is repeated 5 times, it will be 2 into 5, 10. But in a court of law, if you repeat the same law, repeat the same provision for 5 days, it will not make it 5 times stronger. It will be the same thing. So we have already taken note of that, what you have submitted.
Oblige.
Yes, Mr. Madhukar.
My lord, regarding
We
the,
are just pointing out, just
My lord.
something for you to think about and submit.
Yes, yes, yes.
So,
my lord, there is another judgment that I have just now given.
That
citation
Karnataka
to
judgment.
it. My lord, that I will read in the context of the right to food and corresponding duty on the part of the state to provide them food, my lord. My lord, first, if your lordship permits me, before I go to the judgment, my lord, I would like to deal with certain provisions of the National Food Security Act 2013. Because a submission was made that under this act, right to food or the food provision for foods. What would be the position, my lord, under this act, my lord, I would like to.
which provision?
My lord, section 3 first, my lord. Section 3 comes under the chapter provisions for food security.
This NFSA,
My lord,
chapter 3.
chapter 2, section 3, my lord.
Chapter 3, section 3. Sorry.
Section 3 reads like this, my lord. Right to receive food grains at subsidized prices by persons belonging to eligible households under targeted public distribution system. Every person belonging to priority households identified under subsection 1 of section 10 shall be entitled to receive 5 kilograms of food grains per person per month at subsidized prices specified in Schedule 1 from the state government under the targeted public distribution system, provided that the households covered under the Antyodaya Anna Yojana shall, to such extent as may be specified by the.
No, but they have to be covered by the targeted public distribution system.
And that is why I want to come.
Or by the Antyodaya Anna Yojana.
Well, that is what I want to show, that they will not come within that scheme. Well, I am not for a moment saying that they are not entitled to food for their survival, but I am only showing that under this act, possibly there will not be any obligation on the part of the state. This is what I want to show from here. First, it's my section 3, Lordship has seen, there is one scheme called Antyodaya Anna Yojana and under the targeted public distribution system.
So there are 2 schemes. One is targeted distribution system, one is Antyodaya.
Mine.
Antyodaya possibly gives something more
Yes, ma'am.
and targeted gives something a little less
Yes.
possibly.
Yes, yes. Now, my lord, subsection 2, Lordship may kindly say for a moment, 3 subsection 2. The entitlements of the persons belonging to the eligible households referred to in subsection 1 at subsidized prices shall extend up to 75% of the rural population and up to 50% of the urban population. Now, my lord, section 10. Section 10 says state government to prepare guidelines and to identify priority households. The state government shall, within the number of persons determined under section 9 for the rural and urban areas, identify households to be covered under the Antyodaya Anna Yojana to the extent specified under subsection 1 of section 3 in accordance with the guidelines applicable to the said scheme. The remaining households as priority households to be covered under the targeted public distribution system in accordance with such guidelines as the state government may specify, provided that the state government may, as soon as possible, but within such period not exceeding 165 days after the commencement of the act, identify the eligible households in accordance with the guidelines framed under this subsection. Then, as you also see, my lord, in the beginning of this section itself says, the state government shall, within the number of persons determined under section 9 for the rural and urban areas.
So
identify
that
this.
means
My lord.
70% for rural and 50% for urban.
Yes,
What is provided in 3(2).
yes,
Because 9 repeats that only.
yes, 10. And
No, no.
then 10 says this identification will be under section 9.
That's why I said
Yes,
9 provides what is referred in 3(2).
yes. Now, Lord, may kindly see 9.
Hmm.
9 says coverage of population under targeted public distribution system. The percentage coverage under the targeted public distribution system in rural and urban areas for each state shall, subject to subsection 2 of section 3, be determined by the central government, and the total number of persons to be covered in such rural and urban areas of the state shall be calculated on the basis of the population estimates as per the census of which the relevant figures have been published.
So this is where 9 is basically clarification of 3(2). 3(2) says whenever it is rural area, 70%, it should be at least 70%. And when it is urban area, 50%.
Minor.
That depends on the actual population of the given area.
Yes,
And 70 and 50 respectively will be covered either under the Antyodaya or under the targeted.
targeted. And my lord, section 11 then further says, publication and display of list of eligible households. The state government shall place the list of identified eligible households in the public domain and display it prominently. What I'm trying to project before your lordship is, my lord, under the Foreigners Act and under the relevant rules, when a person is declared to be a foreigner, he will be taken into custody. That part is there, my lord. He will be detained. There he will be in a specific area. So question of distributing.
Mr. Mojumdar,
Man.
moment you take the man in custody,
My lord,
it is your 100% responsibility to provide food.
my lord, yes, that
Food
I'm
and
not,
shelter.
that I'm not disputing.
So we are not looking into what will happen to the people who are taken to custody,
Yes,
because custody is for a very limited period
limited.
and maximum is possibly 2 years. Supreme Court is asking that beyond 2 years, release everybody.
Really,
So people who are taken in custody, for their food is not a problem,
yes,
because the state, by virtue of taking them into custody, is bound to provide them with food.
my lord. Even otherwise,
Even otherwise,
Right.
what we are looking at is if you don't take these people to custody,
my lord,
the deportation process is yet to be given its logical effect.
my lord.
They will remain in this country to be declared foreigners. We are looking specifically what to do with this category of people. So as you are submitting, their neither to be included in the Antyodaya scheme, nor to be included in the targeted distribution scheme,
Right.
nor they will be within that 70% rural,
Yes,
nor they
yes.
will be within the 50% urban.
Right.
So they will acquire their food, possibly, only one way of looking at it, in the same manner in which the balance of the rural portion, 30%,
Hmm.
and the balance of the 50% urban population will procure their food.
Balance.
Because these schemes covers 70% of rural and 50% of, I think 3(2) is very clear.
Yes.
Entitlements belonging to eligible household referred to shall extend up to 75% for
Yeah.
rural and 75%.
Yeah.
And 50% of urban population.
Right.
This means the entitlements under section 3
Right.
will not be available to the balance 25% of the rural population
No.
and 50% of the urban population. So these people will be in the
Other. Remaining.
the way
remaining
the
group.
other balance percentage who are not entitled to these benefits, they acquire their food. These people will also acquire the food in the same manner. This is the only way we can look into the problem.
Yes. Now.
So again, ultimately, we are coming back to the question.
Right.
3(2) envisages that section of the population by not bringing them within 25% of rural or 50% of the urban.
Yes.
Because they are capable to acquire
Earn.
their food.
Right.
To purchase their food or procure their food. They are capable. The law understands that they are capable. Here may be a section of people.
Right.
Of course, not everybody. Somebody may be more than capable also.
Yes.
They may not be capable to procure their food.
Right.
So you will have to provide them with some means through which they will be able to procure their food. One means is you have to give them some kind of, allow them to work. If you cut off their right to work also,
Then how they will acquire?
how they will acquire the capability to procure the food? Maybe in a regulated manner,
Right.
maybe in a manner where you keep track of everything as to what they are doing, where they are working, but you'll have to allow them.
And now, for the second part, possibly the judgment will be of some relevance, my lord. That's AR 22, Karnataka.
Hmm.
I will straightway go to, my lord.
There, the petitioner is a national of China
Well, China.
in a Karnataka case.
Mine.
Okay. Which para you are looking?
I can go straightway to para 4, my lord.
As to what the jurists of international law say about rights of aliens in the host nations.
Yes. Thereafter, one more page.
Oh, पूरा नहीं ले ना assembly किसने assembly किया अपना ना itu dua ना itu assembly
Yeah. Karnataka 40. Paragraph, last paragraph. Okay. Oh, no. Nine. Which is
What is provided in Hassan Ali Raihani versus Union of India? Do you have that judgment with you? Here to Samsung 2006 3 SCC 705. 5. 2006 volume 3 705.
Hassan Ali Raihani, because it is 143705.
But one aspect of the matter, most of these judgments are either people who are overstaying their visa, they came in legitimately
Entry was lawful.
and refused to go out. And here is a case we are dealing with. Numbers are very difficult to say, maybe hundreds or lakhs or millions, you don't know, the people who were possible, you can use the word forcefully came in. And some of them are detected by a procedure of law. What to do with them? Ideally, they should be deported.
Yes, first.
Deportation is,
The first.
you say that it is some bottleneck is there. Some
Still-
obstructions are there, you are unable to do it. Now, what to do with these people? And that to not do en masse.
En masse.
It's not a matter of one man. There is all those judgments are a matter of only one person. What to
Yes.
do with that man?
And in those cases, my lord, the alien country is not refusing to admit that he belongs to that country. But here the difficulty is the country is not accepting that they belong to the same country. That difference.
And the international law is, it may be a discrimination
Yes,
requiring the country of origin to take it up.
yes.
If the property is taken away,
Yes.
then you have to go to the country of origin, then they will take it up. And here possibly there was an act is also there in Assam. In Assam or it's a India, I don't know, one act is there
My lord,
under property.
property, possibly.
Yes, one act is there.
Yes,
I
possibly.
remember reading. some-
Central Act, I think,
Well, maybe it's a central
Aliens
act,
property,
maybe
yes.
it's a central act also.
Central Act.
One particular act is there.
The Central Act.
So ultimately, where do you settle?
My lord,
Till now,
my lord,
what Mr. Awan and Madam Ghosh, what we can arrive at reading all these laws till what has been submitted till now. About your health, you give them health without any restriction. Mr. Majumdar,
my lord,
They give them the benefit of health without any restriction.
Yes.
At least the government dispensaries and that health
Yes.
system. You can't allow a person to remain ill without giving treatment, whosoever he may be.
Yes,
Education. Give them the education. Why do you prevent them from giving education? What interest of the state is lost by giving education? You can think of whether it will be absolutely free or you charge for something. That you take your own decision on that. Right to food. It appears from what is being submitted, you don't come within the category of that 75% of a rural population or 50% of a urban population to get the benefit of this subsidized food. This is basically a provision of subsidized food.
subsidy
It's not that provision of only food.
and for targeted people.
If we go by section 3(1) CC, this category of people will have to earn their food. They have to pay for it. If you take the ground reality, everybody may not be in a position to pay for their food. How to overcome it? You allow them to work in a regulated manner. Then residents, you earmark certain areas where they will be allowed to stay. Earmark certain areas where they will be not allowed to come. That you can do under the law. Certain areas you prohibit them, certain areas you allow them to reside. Definitely, wherever they reside, they will not get employment. It's most unlikely. Unless in the agriculture sector or so, it's most unlikely. So they have to be allowed to work in the tertiary sector also. That you do it in a regulated manner.
For that, possibly this section, paragraph 4C of the judgment will be of some relevance.
Of which one?
This Karnataka High Court.
Karnataka is on one person, so we are not very.
No, what I'm saying is, madam, here it says,
No, wherever it is of for the general purpose, we are taking account those provisions of law. But wherever it is for one person or for a specific cause, you cannot consider that to be the applicable general law. That is basically for the specific case at hand.
no, it
So-
says, it says, man, it should be left to the wisdom of the government. In that connection, there's one paragraph.
And now difficulty is we are dealing with a huge number of people where the wisdom has not been exercised. So therefore, we are looking into the problem. Had it been exercised, you would have told us that this is our wisdom,
Yes,
this is our
yes.
doing.
What
Either
I-
we would have said yes, or we would have asked you to modify it to some extent.
Like, what I was thinking is, this issue has never arisen in any other case. Now, taking a cue from the judgment, whether
No,
subject
no,
to
no,
what
no,
lordship does here.
let us think a
Direct
little,
the
let us think a little forward.
No, no.
Suppose this person, whoever is declared, was working in an agriculture field of his own. Law will possibly entitle you to take over that property. Possibly, it appears so.
Right.
If you take it over and allow that man to work there and earn his livelihood through that only.
That can be one mode.
He won't be the owner of that property, but he'll be utilizing that property to earn his livelihood. For that, you can regulate it.
This is one way of thinking at it.
This is one, possibly one way of looking at it.
Right.
And if a larger area is taken over, form some kind of a cooperative or something of this aspect. Don't use any other labor to use those land. Use these people from who you are taking. He will not be the owner. He'll not be the owner of all the produce. But it can be regulated to ensure that he has his livelihood. if a particular section cannot be accommodated in these kind of sectors, suppose someone does not have any much land also. Allow them to work in the tertiary sector in the urban manner, in a most regulated manner. Say work permit to be renewed every 3 months. The man will be here with that permit, he will do all kind of works, he'll earn his livelihood, he'll earn his food.
This is,
It's not a source of employment. It will be source of his self-employment, but you will only enable him to have that.
Right.
Means don't bring restriction in that one. And then you take a call finally, what will you do with these people?
yes,
Till you take a final decision or give effect to the final decision. Let this be an interim arrangement, it will go on. If interim is over a long period, let it be for a long period.
in fact, minority.
And every person
Right.
give him an identity of a different nature other than the identity given to a citizen. Adopt the same principles.
So as to.
Adopt the
distinguish.
same principles, but they'll be categorized as non-citizen. So with that, they may not be entitled to every entitlement of a citizen. Whatever entitlement you give them with that identity card, they can use it. And they can use that card for all purpose. Wherever there are restrictions, they'll not be able to enter that area. This will require a much more broader decision on the authorities. Where you will allow them, where you will not allow them. I think within the
Yes,
contours of law, it appears you may not be entitled to anything much more than this.
and it,
Rest Supreme Court has already settled all the things. If you take out what Supreme Court has provided in different judgments and cull out them and bring into one, you'll get the picture what you are entitled and what you are not entitled. Think over. Maybe we can
my lord.
think in that line. Your human rights is taken care of. The basic 4 rights you are claiming is taken care of. If you are happy, remain. If you are unhappy, they may go back also from where they came from. But if you come and illegally stay here, this is what maximum will be entitled. It will be made known to all. If you want, you come. If you don't want, you don't come. If you want, you stay. If you don't want, you don't stay. It will meet the requirements of all the international provisions of international law, what we have been taken through till now. If there are some more provisions, you please bring it to our notice. We'll go through that also. If there are provisions beyond this. And when we have examined 3-4 Supreme Court judgments, where these laws are quoted, maybe it is exhaustive and this is the precise position of law, so we have to accept it. If there are some more provisions, you can bring it to our notice, we'll definitely go into it. Think over, we'll hear you again on Monday. And tell us if you are agreeing, we can pass our order. If you are not agreeing, you want to bring in something more, please, you are welcome to do so. But it should not be rhetoric, it should not be sentimental, it should not be this, it should be specifically what the law provides for. We'll definitely look into it. Dr. Mujumdar, what do you think?
Yes, yes. And what your lordships are thinking, the contours may be provided and then the should be left to the discretion of the government. As per these contours, you.
No, once the contours are provided, not
modus operandi,
discretion.
they will, modus operandi, they will decide.
How you do it is your
That's what.
but Not left to the government that if you want, we'll do it. If you don't want, we'll not do it. No, that we cannot leave it to that extent.
Contours your lordship may provide.
Controls means it's a requirement of law. You do it.
Yes, yes, under the law, absolutely.
Do it, regularize everything.
Right. In fact, my lord, this requirement of thinking about all this has come after the Supreme Court has said that after 2 years, you have to release them. After that, only this question.
After that, nothing is provided. What will happen after that?
Mind, that's what I'm saying.
Even the Foreign Tribunal Order 1964,
Doesn't
to the
give-
maximum, it goes to take them for internment and detention.
There are nothing there.
The stage after that, it's not visualized anywhere, nor provided anywhere.
No, it's not.
What will happen to these people?
Yes.
And mind you, they are human beings. You'll have to take note of that.
Yes.
They are not something different.
It's the time has come now.
How you, whether you like it or you don't like it,
Something has to be done.
something has to be done. So you also enlighten us even more if something more is there in any provision. Any provision which is under the law is
Permissible.
permissible and accepted. Not those demand kind of things. There's a distinction between a demand, wish, and a entitlement. You stick to the entitlement. Demand and wish, you take it up before some other forum. The forums which can accept your demands and all. Court of law can't do it. Court of law will determine only entitlements, rights. And on your demands, if they provide you, it's well and good. You enjoy it also. No one will prevent you from that. I think basically these are the contours.
Will be reported how they were optimized. Supreme Court will be one. We are thinking about something where there is no law, no judgment. Yes. Very difficult to make solutions. On the one hand, human problem, on the other, law provides that aliens to leave.
And will anybody else would like to address the court? Anybody else? Not the present, I mean. People who are not even present before the court today. If they would like to present their views, they can come forward. If somebody has some better knowledge, better idea, better concept,
They are welcome.
you're welcome. Otherwise, we'll have to conclude at some stage. We can't go on and on with this. And Monday, let's see if possible, we can conclude also. We're going to hear you Monday. Just anything further you want to add?
Tomorrow your lordship will take up again.
Should I take up? Let it be on Monday. That will be on Monday because we are giving some in-between period for everybody to brush up also and see if you find something more. So
Only for Monday, I'll pray that I
You're
have
having
some
difficulty.
difficulty. Tuesday, second half, my lord.
Tuesday, yes, Tuesday.
In the meantime, I'll do some more
See if something more is there.
research.
So what do we have till now? The three Supreme Court judgments, Sarbananda Sonwal and the Sanmilita Mahasabha. These are the judgments on basically on immigration.
Well,
Then we have this Hans something, what is called?
Yeah,
Hans Nuremberg.
Hans Muller, Nuremberg.
Then one Louis something,
Louis
Louis Rate or something.
Reid,
These are the two original judgments.
then Bhim Singh,
Then Bhim Singh,
then Khudiram.
then we
Chapman.
have Khudiram.
Right.
where basically the provisions are discussed, and one Karnataka High Court.
Laid down.
Whatever the Karnataka High Court may have laid down, but they have referred to a lot of materials.
Might.
If those materials indicate anything.
Right. These are the materials I have
These
found,
are the-
so far as our judiciary in India is concerned.
And if you have something more, you're. Oh, What are these foreigners restriction on residence order 1968? Are those provisions any relevance here? Foreigners exemption order 1957, Foreigners Marriage Act, Marriage Rules, Citizenship Act. Passport.
Those cannot be directly,
Hmm. And what about this immigrants expulsion from Assam Act 1950? What relevance this one has?
this one will have relevance only in respect of the
Because
Religious
otherwise, the
persecution.
registration of Foreigners Act, registration of rules,
yes.
we'll examine this, whether this category of people, they are required for any registration, etc.
Might.
Foreigners Tribunal Order, these things we have already gone through. Notification regarding foreign, four notifications of 2006 and 9. Foreigners report of police order, restricted areas. What is restricted areas? Just go through this.
Might.
Foreigners protected areas, notification. Foreigners restriction on Pakistani nationals order. Restriction on Pakistani national order 1971. What are these?
These are possibly,
105, 106. Are they
they
are covered by casus amicus, casus amicus, or they are still relevant?
Possibly it will be cases same, I guess.
Or civil
Casus
authority means
amicus.
no Pakistani national or British subject other than a citizen. Shall leave the local limits of the city, town, or village in which he is resident, absent himself from prison for a period exceeding 24 hours without obtaining prior. These may be relevant in regulating. Because what is stated to be Pakistani
Might have,
in 1965,
might have.
after Bangladesh, I think it has to be read both Bangladesh and Pakistan. Provisions are remain.
I'll look into it.
Pakistani national 1971, if the local limit without obtaining.
Pakistan.
Some kind of regulation possibly about the
Regulation,
whereabouts.
Yes.
Means you just can't go anywhere you feel like. Foreigners restriction on movement order 1960, foreign restriction on activities order. 115, what are the activities restricted?
As your lordship has said, my lord, for the present moment, in the absence of any other rule, also this will help as cases omissus.
Which one?
These two acts. the
No, if
orders.
it is casus omissus, then it is gone. You cannot rely on it.
My lord, both these orders are under again in exercise of power under section 3 of the Foreigners Act.
Understand? If you say casus omissus, then it is gone. It's no longer valid.
No longer.
But if you say they are still valid and applicable,
My lord.
maybe you can regulate.
Possibly, my lord, so far as the Pakistan one is concerned, 1965.
No,
They-
71, 71 is
Yes,
also there.
71 is different.
Same, provisions are same.
Provisions are same, only
Hmm.
this one deals with. uh, Year six. Then 17 Vijay Pakistan.
Amending Act 1957 and XXX one of 1997. Whether you can amend way as a repeal way as a amendment. No, I repeal by almost section 2 or section 2 repealation, repealation, right? Hmm. He repealed for his something. So we repeated 57 on notification also 63.
These two orders would not be relevant for our placement. These are strictly for Pakistani national at that time.
So according to you, if these are Bangladesh nationals of Bangladesh, now after creation of Bangladesh, the word Pakistan has to be read as Pakistan and Bangladesh. For Bangladesh, you will not take out a separate order. Immediately after the existence of Bangladesh,
My lord.
when the area covered by Bangladesh is included in the area, it's after creation of a different country by different name of the same place. Just because the change of name may not take away the applicability of the law.
These two orders possibly were issued for the purpose of restricting their movement till they leave the country or something like that, because it says,
No, restricting the movement.
yes,
So restricting the movement is, see, it is consistent with the provisions of section 3(1)(e).
my lord. First
3(1)(e) also you can restrict the
Yes.
places.
Well, first one restricts, and the second one, there is 71, goes further to say no Pakistan national employee in I'm sorry, no.
So,
yeah.
no, they'll have to keep the authorities informed about the place of residence. That
Yes.
is the main purpose.
That is the main.
And if you change your residence, you'll have to inform. And
Take
in your
permission.
residence, if you are beyond 24 hours, then also you'll have to inform.
And without obtaining permission, you can't do it.
You cannot do it. So why do you say it is not applicable?
And it is applicable only in respect of Pakistan national. For the other, if you. are
Again, same thing. It's only now a change in name.
But then for that possibly a separate order has to be issued by the central government in exercise of section 3.
Think about it. It's up to you. But there are two ways of interpreting it.
My,
If you think that this law is applicable for people coming from a particular area, that area is given the name Pakistan.
same,
And the same area at a later point of time is given another name. Because merely
clearly
because
means-
the name has changed and the identity has changed, does it ipso facto mean that the law will be not applicable, although the area designated or a area indicated is same?
territorially same.
Territory is same. Now, there are both ways you can look at it.
Minor.
One go by the name, one go by the territory.
And
Become 55. এখন কত আছে? এখন পাইছে আমি। এখন তুমি হেৰি চোৱা, XX UL of 1956 of 1957. এখন কি আছে চোৱাচোন।
second one, my lord, is sub 71 order deals also with the question as to how the,
No, that provision is otherwise very good.
yes, that's what I'm saying, my lord.
You
They-
can
they are saying-
regulate the existence of.
First one regulates and second one, although specifically for a particular group of people, no Pakistani national employed in a Pakistani diplomatic or consular mission.
No,
For
that that is for deployment.
Yes.
That is not applicable.
17, okay.
We are
71,
not going for the one, we are going for the section 3, we are going for section 2. To regulate the residents.
yes,
Otherwise, what will happen?
well,
If you detect, you ask somebody to remain in one place, the man disappears from that place. He'll again assimilate with others. Maybe assume a different name, maybe assume a thing, then start playing the same game again and again. How do you control all this
well,
if you don't regulate the residents?
65.
Regulate.
71 has been rescinded, my lord. Second one has
And-
been rescinded.
And the government is, under the law is required to indicate their residence also. May not be provide, but at least indicate that you will reside within this much. Reside there, within this much. Say the city of Guwahati, you say, you can reside here. You can work here. You keep informing exact address where you are staying. Time to time. If you change, you inform. And you go on. Yes, Mr. Owen, don't you think that's it? You'll remain where you are, except for that. Your rights and entitlements will be clear, what you are not entitled, what entitled, but otherwise you'll remain where you are. The place where you're presently residing, that itself can be declared to be the place where you stay. But only thing will be regulated. On your own wish, you just can't keep on moving wherever you are. If you want to move, inform the authorities, go to the other place also. Say today you feel that Guwahati is not a good place for livelihood, Dibrugarh is a better place. Inform them and go.
Decision is there, 71 decision is there.
Because some of your requirements you'll have to forego. And something more which is sought to be taken away will protect that also. Strike a balance. Remain confined to what you were entitled. Or you think of something different?
Bail condition.
Sorry,
Condition.
I think microphone is off.
Sorry. So there's a condition,
Sorry,
there is a condition for bail that the person,
condition for?
bail who were released after 2 years.
See, bail is only when you are detention.
I know.
We are not contemplating of a situation of detention.
I know.
So where is the question of bail comes? Where does the question of bail comes from?
Those who are already been released, those who have been released,
Yeah.
they have to comply with that condition.
You comply, or else if that condition is bad, go and apply again in that court which has applied for
Right.
modification of the.
Right.
But this is not generally applicable.
Right.
And here you are a free person. No one is giving you anywhere. Except for the certain restrictions. That's all. Which, as per they point out, which you are under the law, you are not entitled. Otherwise, you are a free man to move, do everything. So Article 21 is also protected.
Right.
Mr. Modimdar. Is this act still in force? The page 116 of the blue book
Yes, yes. ma'am.
is still in force.
Yes,
What is the meaning given to section 7? Next
Seven.
page.
repealed by repealing and amending Act 1957. Schedule 1.
Yes, Madam Ghosh, you must be knowing. Because sometime back you argued one matter by relying on this act. Is this act still in force?
My knowledge,
Sorry,
as per my knowledge, is in force. If
what
I'm-
about next page? What is stated there?
Section 7. Repealing.
Section 2 of Schedule of 57. Repealing.
Uh-huh. Repealing Act 36. We can refer to this. Hmm. Specifying procedure repeats the extent mentioned in the fourth column. If it is about section 7, repeal is 1 to 6 procedures. Understood anything? What is stated in page 118, have you understood? Have you understood what is stated in 118?
Yes, ma'am, this section 7, my lord. Within bracket is repealed by repealing
Yes.
and amendment act. Normally, this sentence under the brackets, my lord, is
Read that red marked.
Right.
And then read section 2 of that amendment act. The one on your left hand. Read section 2 of that. So some of it provides that the acts enumerated in that schedule 1 or the schedule 2,
my lord.
they are amended
Yes,
or repealed. Okay. And extent of repeal is to whatever is provided in column 4.
that is section 7.
In most of the acts, you see it is written whole. That means the whole of the act is repealed.
But
For
here,
this act, it is stated only section 7.
section 7 has been repealed.
So that means section 7 is repealed.
Yes.
Section 1 to 6 still survives.
Yes, sir, right. This is particularly, my lord, section 2 proviso says for the proviso, my lord. Section 2 says if the central government is of opinion that any person or class of persons having been ordinarily resident in any place outside India.
So this way we understand that this act is still surviving.
Yes, yes.
It is not repealed.
Yes.
Only section 7 is repealed.
7 is
That is the saving clause is repealed.
saving clause.
Saving clause of whatever was done by the act that existed prior to this act.
Right.
So now, provided nothing shall apply to any person on civil disturbance or this thing,
Yeah.
what will not apply? Direct such person to remove himself from India or Assam,
Yes.
give further direction to his her removal.
Right.
So there is a restriction on the removal.
Yes.
If you belong to this category, there is a restriction on removal. If you don't belong to this category, removal is also applicable.
Yes. Yes.
Now, once there is a restriction in removal and they are declared, what will the person be entitled to?
This question came up in some of the cases, where but I'm aware of those cases where this plea was taken. Then the further question comes that you have to take specifically the plea and you have to establish that.
Understand, applicability specific plea, you have to establish your plea also. That is another factor. We are saying, suppose everything is taken, a person is subjected to this proviso. There is an order. What will be the entitlement of that person?
Of that person.
Because till now, we have examined the entitlement as per the general law, whatever is projected.
Right.
Now, this category becomes a category a little different.
Right.
They are protected by this proviso.
Minor.
What will be their entitlements? Will continue
Poss-
on Monday?
Minor.
Yes.
Tuesday.
Tuesday. দুইটা মিক্স আপ নকৰিব হা এটো সেপাৰেট দিয়ে থৈ দিব এটো ঠিক
এটা কাজ
I beg to mention item number 4, Lordship. Lordship, in the morning, Lordship, my senior was there, Lordship, but due to some health issues, Lordship, he left the court, Lordship. This is a part-heard matter, Lordship.
One adjournment.
Lordship, I want adjournment, Lordship. I have taken consent.
But
from
we have already heard Mr. Chaudhary.
Lordship.
Only the last few part remains. Only on one issue that the state has to address the court.
Lordship.
What is the concept of a forest village?
Lordship.
This is, we are unable to get anywhere. Where is the origin of a forest village? Other than that rule framed under section 76E or 75E.
Lordship.
Only the rules brings in the concept of forest village. And other than that, there is nothing called forest village.
Lordship.
Village forest is there. Village forest is different. Other than a reserve forest, if any other village, there is some existing forest, the government can notify that to be a village forest for the benefit of that community.
Lordship.
But forest village. So we are hearing basically them on this.
Then,
So if
Lordship.
necessary, we'll hear them. If they have to speak something, you take note of what they say.
Lordship.
Item 1 and 2 for motion.
My lord. My lord, this matter I was supposed to file an affidavit, my lord. We have sent it for vetting. We are receiving it today, my lord.
Mr. R. Dhor, learned additional senior advocate states that the affidavit has been sent for vetting and it will be filed shortly.
My lord.
List again on the next availability of the bench. Date at the video.
20th April. 20. Item 3 for admission.
But that double tick mark, Krishna,
Yes, yes.
who had done it?
My lord,
Because the petitioner is before us
My lord,
saying that I did not do any double tick.
yes,
Now, answer scripts contain some double ticks.
yeah,
And because of the double tick, some less marks has been given.
yes.
That means if the petitioner has not done this double tick,
Some other person.
after submission of the answer script, somebody must have done it. Who had done it?
My
And
lord,
this has two dangerous aspects.
my lord,
If one genuine candidate by somebody unscrupulously putting double tick in his answer script is deprived, that means correspondingly one
has got the
unscrupulous
benefit.
person will be in service. You have to identify, then it needs a thorough inquiry,
Yes,
maybe by the CID also, if necessary. It appears that the magnitude is slightly larger.
Lord,
And if the petitioner is making a false statement that he himself have put the double tick and now claiming I did not do, that is different. Otherwise, just see the imagine the situation.
my lord, I want.
Today, one student, he gives all correct answers. That means on merit, he is entitled to be appointed
Yes.
or selected at least. After submission, somebody puts double tick in his answer script, meaning thereby some of the right answers are now been made wrong. So he is brought down in merit in the evaluation. Moment one person otherwise on merit is brought down, correspondingly another person who will not be fit on merit
He will
will
enter.
be in. If petitioner had not done, somebody else has done, no one will do it for fun. It will be done for a purpose. So we are still at that stage.
My lord, we have filed an affidavit bringing on record the enquiry report. Lordship said that initially the answer script, then
What does it say?
the report we have annexed here. The report, my lord, they have prepared, according to them, they have concluded saying that name of the question setters. The question paper was a multiple choice type and total number of questions were 100. Each question carried 1.5 marks and thus total marks in the question paper was 150.
That is not required. Everybody knows it.
Yes,
We want the inquiry that who had put the extra tick mark. It
yes.
is the petitioner himself or somebody else. Mujumdar, we give you time, you apply your mind and try to ask the inquiry to be made in that line.
Fine.
The authorities, as ordered earlier, shall conduct a further inquiry to find out as to whether the double ticks in the answer script of the petitioner can be attributed to the petitioner himself, or it has to be attributed to somebody else. If it is somebody else who had done it and for whose corresponding benefit it had been done. The contour of the inquiry be confined to the aforesaid question, rather than trying to find out as to how many questions were there and how many and what marks the questions carried. Okay. List again on 20.
Lordship, you give us some time around.
For the
45.
purpose, the origin of the answer scripts be taken in custody
Yes.
by whom? Who is conducting this inquiry?
This NPA constituted a committee of Professor Cotton College, then Director Higher Education. This committee can also keep it.
No, committee cannot find all this. This committee, I think the CID has to do it. Only they have the expertise.
My,
As the inquiry may involve complicated investigative procedures, we direct the authorities in which department?
Food and Civil Supplies.
Which supplies to hand over custody of the answer script of the petitioner as well as the answer scripts of all other candidates in the offending examination to the state CID Assam to make an inquiry as to whether the double tick in the answer script of the petitioner can be attributed to the petitioner or it has to be attributed to somebody else. And if it is somebody else, who is the person and for whose benefit the manipulation in the evaluation of the answer script was done. The CID to take custody of all the original materials from the Food and Civil Supplies Department. Okay, I think this is better.
Right.
And if he himself done, tell us, then we are going to impose cost on this petitioner for making false claim.
Can the copy of this order be directly sent to the Commissioner Secretary, Food and Civil Supplies, so that in between there is no gap? No, we have not received these, that.
No, you take over the CID. CID will do it.
All right. No, they will have to provide these documents to them.
If they don't provide, ask them to take them to custody, the persons. If custody of the material is not handed over by the Food and Civil Supplies, ask the CID to take custody of the persons then. CID can manage, don't worry. They have their own mechanism how to do it.
Yes.
See, Food and Civil Supplies, we are not satisfied at all.
Right.
They are not undertaking the inquiry in the proper earnest.
They could not go to the root of the
They
problem.
are not avoiding it.
All right.
Court on this allegation never asked them to find out what is the total marks of the question, how much marks each question carries. No one asked them to provide that information. So a copy of this order may be made available to
That will be Mr. Sharma.
Mr. H. Sharma, Learned Additional General Advocate, to enable the Learned Advocate General to further proceed in the matter through the state CID Assam.
Sorry, ma'am. I was on Lakes Report number 1.
We asked the state CID to make the inquiry
CID will maintain.
Yes, ma'am. My lord.
because the department is not.
I have gone through the reports, my last time I was served with this, my lord. I find, my lord, these are in contradiction, variance with the earlier affidavits filed by them. Ma'am.
No, that will decide this
Yes,
one. on the judicial. We want to know this extra ticks is given by the petitioner himself or it is given by somebody else. If it is somebody else, who? List for further hearing on 2023.
Yes, madam. Let this CID.
And possibly the petition had not done, otherwise he would not come to the court and be agitating in this matter.
My lord.
Why should a man, after doing a mischief himself, come to the court and agitate it? Must be done by somebody else.
Well, two things I wanted to submit, my lord. So far as the ink, color of ink and, my lord, one way is to, my lord, compare the ink.
No, we asked the CID. CID will take custody of all the answer scripts.
Yes, madam.
And,
Here they said there is no.
and
anonymous
how the
answer.
CID does it,
Yes.
we don't
So they will-
guide them.
they will exercise.
Let the CID apply its own mind.
Yes, madam. So possibly allow some time for it.
The next hearing is 20 April.
20th.
20 April.
Time. Let them have a month's time, madam.
Puja hall.
Make
Puja hall.
it,
First week of May or something.
make it 27 April.
Yes.
Yes,
It will be only 2 days short of a month.
yes, 27th.
My lord.
I would return.
Obliged.
Much obliged.
Item 4.
Mr. Gogo, you are ready?
My lord, no, I have to seek, my lord, possible, Mr. Swami is addressing report 1, my lord. He is on next.
Goswami will be coming.
Item 5 for orders.
This is a matter regarding challenge of gradation.
Anam Burman.
Lordship, my
The
senior is not.
Young
well.
counsel is looking very anxious. Probably she would likes to say something. Yes,
Lordship, my senior is not well yet.
the senior is not well. Who is your senior?
UK Nair, sir.
Huh?
Mr. UK Nair.
UK Nair is not well.
Yes, he had to leave court. Lordship.
It's stated that Mr. UK Nair, Learned Senior Counsel, is unwell today. to be listed on that 27. 37 will have the single bench again.
27th of April.
April.
Much obliged.
Item 6 for hearing.
6 is well, Lordship. I'll be taken up at any convenient date, Lordship.
Let item 6 be called.
This is 6.
Lordship.
Your prayer was made before the item was called. Let the item be called at least.
I apologize, Lordship.
Okay, 6 also, same order.
Much obliged, Lordship.
7.
May I please, Your Lordship? Kindly fill the order dated 4/3/2023, Your Lordship.
Lordship, by that order, Lordship has directed us to file an affidavit by bringing some records. But Lordship,
You file an affidavit.
no, Lordship, we have not.
You want
yet-
time?
Lordship.
Mr. H. Sharma, learned additional sitting on advocates, seek for some further time to file the affidavit as required by the order of 14/3/2023. Pray aloud.
We have not yet received the instructions.
List on 27. It is expected that the affidavit will be on record before the next returnable date.
8 and 9.
That Sosostro Sima. I think the officer was here. Most of the first half he was standing outside the door. Yes, yes, yes. That same question, you are Mr. Chakraborty. Eh?
Sir.
You have a rank. You were addressed as Mr. or through a rank?
I'm Padmanabha Chakravarti. Myself, Padmanabha Chakravarti, Lordship.
Sorry,
Myself, my full name is Padmanabh Chakravarti.
I know Padmanabh Chakraborty. No, you have any rank before your name or you are addressed
Yes,
as?
my rank is actually Deputy JAG.
No,
and the
That's
rank
not
of
a
Deputy
rank, that's a post you are holding.
Deputy Commandant.
Deputy Commandant is also a post.
Yes.
Anyway, have you thought about it?
Your Lordship,
We understand what the projections you were trying to make, and don't repeat the same thing again and again. There are two procedures. One is summary court, and other is force court.
Summary Force Court, Petty Force Court, and General Force Court. There are
General force court and summary force court. According to you, whenever a person is Havildar or below, across the board, whatever may be the allegation, whatever may be the offense, it will be the summary force court. This is what we understand by your submission on the earlier date.
Yes, sir.
And general force court is only for officers who are above that rank,
Right.
if necessary.
Yes, sir.
We are asking a question, how can it be? If the offense is heinous, if the allegation is serious, if the implication thereof will be that the person will be dismissed from service, every law of natural justice, irrespective of the provisions of this, your act applicable, requires that before a stringent action is taken, the man must be given every opportunity to defend himself. The requirement of the procedures of a summary force court, after reading through the rules, I think we are referred to two different provisions of the rules, one for summary and one for full general force court. It appears that the summary force court is a little summary in nature. The complete opportunity may not be available. If this is so, how can you take a more stringent action against a person that is dismissed from service by giving him an opportunity which is less than a complete opportunity and merely refer to a provision of law which says that you are a man of rank of Havildar or below, so therefore your treatment will be of this nature. Had you been an official of a higher rank, we would have given you a different treatment. This will violate Article 14 of the Constitution. Only by virtue of rank, vis-a-vis the proposed most stringent action to be taken, there is no reasonable classification between a person who is a Havildar and below and a person who is Havildar and above. That intelligible differential is unavailable. If we interpret the provisions of your act in the manner you are projecting, it will violate Article 14. So this interpretation has to be rejected. Now please submit. Either you submit or let the learned counsel submit. Because it's absolutely a question of law. And how you understand the law, we are not much interested. We are interested to know how this law is to be interpreted. And Madam Devi, we have heard it for quite long. Don't repeat the same thing again and again, because last 3 dates we are basically coming across repetitions. And on the last date, Mr. Rakeli also came in this matter.
Number 1.
And this may have some implication on the interpretation of the laws. So we want to give a complete hearing. But fundamentally, don't you think so? There are, by virtue of the position or status of a person, he cannot be, there cannot be any reasonable classification for the purpose of holding a proceeding and imposing the most stringent punishment. So if that is permissible, you can frame the laws in a far better way. What is the rank below the Havildar? How many ranks are there below the Havildar?
Constable, we call it, Your Lordship, we call it constable and head constable. And
So 3. So now if you bring in one more legislation, that if a person is a constable, you don't have to put him any summary force course also. The commanding officer can straight away pass an order, you are dismissed. You can bring that kind of a law also.
Your Lordship, there is a provision, the commanding officer may refer the matter to higher authority for convening higher courts. But commanding officer has the power to deal the matter.
Mr. Chakraborty, please don't compel the court to repeat the same thing again and again, just because you would like to repeat. You have said it on the 2 earlier occasions. And before making a submission before the court of law, understand the law completely. We are not hearing you as a layman that you say whatever you feel like. We are hearing you as a responsible officer who is well versed in the law. And law means the entire gamut of the law. And not what occurs to the mind of your commanding officer. That is not a law.
Section 84, 85, 86, it states the difference between general, petty and summary court.
Madam Devi, we have argued that a number of occasions. We have heard you on a number of occasions. We have already examined that aspect. Don't repeat it.
Yes, general force court examine all the.
Madam Devi, answer within the contours of the question raised, not beyond that. That whatever question you raise, I am going to give only one answer every day. Will not accept it. In an examination, can you ever think of that I will prepare only one answer? Whatever question you may put in the question paper, I will give the same answer. Is it ever possible? We are asking a very specific question.
Yes.
Commanding officer has the discretion in respect of people Havildar and below. Now, what Mr. Chakraborty says, he also has the discretion that he may refer it to a court of a higher level, that is the general courts court. How do you exercise a discretion?
Lordship, as per,
Please don't refer that. Answer is not there.
as per it is,
Answer is not there. What is the law of discretion? Please submit on that. How a discretion is to be exercised.
as per this section, the summary force court may try any person subject to this act and under the command of the officer holding the court. So this is a specific category under his command, those persons who are under his command, only those persons.
So
he
we
can try.
understand that the respondents have nothing to submit on the question raised.
Lordship.
Record it and pass our order against it.
Lordship, may kindly, further,
In spite of repeatedly asking if you are giving a different answer, we record your answer and observe that the respondents have no intention to and they have nothing to say on that question. We'll do that.
where Lordship immediate action is required. In that case, he can hold the summary force court. Otherwise, he can refer it to the petty force court for constituting the general force court or Lordship petty force court.
Why? What immediate action? If this man is a very dangerous man,
Lordship.
you don't have to take immediate action, not to give him any opportunity of hearing and dismiss him. You can put him in custody. You can restrict his movements. If he is a dangerous person.
In summary force court also, he is given opportunity to examine, re-examine, and defense counsel, everything, Lordship.
Nothing. Let us see the record. What are the opportunities given, if it is so. Flag mark the page where he was given the opportunity to say everything. And mind you, if the submission of the Union of India, we accept it,
Lordship.
at least we exercising the 226 jurisdiction will be very happy to accept it. Because from tomorrow we'll understand that as per the Union of India, discretion means you can do anything you feel like. So we apply the same principle in the court proceeding against Union of India. We'll feel that we'll do anything we feel like. Because it is the stated stand of the Union of India. From next day onwards, you will, if you start conducting every proceeding against the Union of India by taking the principle of discretion as you understand, what will you do? In our discretion, we have that order. We can pass an order that Mr. Chakraborty will do this right now. We have the discretion. We can do it. Now, without any rhyme and reason, if we start doing it, that in the name of exercising discretion, will you like it? Same is the situation with your commandant.
The order is not final. They have the opportunity to appeal.
You are going towards a cost being imposed on your client. Slowly, you are taking that direction. We have asked you a most fundamental question, how discretion is to be exercised. Because the officer is taking a stand that the commanding officer has the discretion.
Yes.
He may either send it to the higher court or he will do it in the summary court.
Summary.
Next question we are asking you, under the law, how a discretion is to be exercised. And you are not answering that. You are answering many other things other than the question. And if it is your understanding of the Union of India, a discretion can be exercised in a whimsical manner without any reasoning, without any, in a most, and it's a most unbridled and unfettered power in this world. That's why I said we'll be very happy to accept that definition. From tomorrow, the courts will also start functioning the same way.
Otherwise, discretion is to be exercised when immediate action is required.
Sorry,
Otherwise,
you are wrong in that also. You're absolutely wrong in that.
Because 86.
You cannot
yes,
accept
yes.
that when in an urgent basis, something has to be done, you can do it whimsically. Mind you, Madam Devi, you are on a very, very fundamental legal principle. And your submissions appears to be
Gravity of the offense is main consideration as per this section 86.
let us see. Section 86. Then we do one thing, very well, we accept everything, we set aside everything, we release this man, put him back in service then.
No, that's it.
We are thinking of providing for something for the benefit of the force. If these are the submissions you were trying to make, we'll pass on order. We find everything arbitrary. We'll set aside the whole thing and direct you that take him back in service. Very good.
Because let's say in the act or rule, there is nothing specific that only in these subjects discretion can be exercised or
Very well.
not. Only the gravity has been.
So where is the concept of law that if a given statute does not provide for, none of the accepted legal principle is applicable? Where is that? Natural justice is not applicable, legal principles are not applicable. Why? It is not provided in this statute. Please stop it, Madam Devi. Be fair. Come prepared. Argue your case. Don't just beat around the bush like this. If you do so, all the submissions you are making on this legal principle, we are trying to require your submissions will be against you. Consequence will be against you. We are just trying to provide you. We know that this man has done his conduct is not at all acceptable. But under the law, he is entitled to a fair treatment. And whether invoking this section 86 will be a fair treatment in this case. That is the question. If you say so in a more adamant manner, that our commandant has the discretion, he can do anything in this world, we'll also pass our judgment on that. If it goes against you, everything will be set aside, meaning thereby the person who had done an heinous offense will be back in service. This will be against you. You better come to terms.
Yes, yes.
If actually you have not given him the due opportunity, we'll allow you to proceed further against him by giving him the due opportunity. Ultimately, end result, the order may be same. He may still be dismissed for service. But that doesn't mean you'll not follow the law.
Yes.
And there is nothing called emergent nature. What about then death sentence? If I follow the same principle you are trying to urge upon, a person who had committed a heinous criminal offense where death sentence is justified. So therefore, what the system should do, don't give him the proper opportunity to defend himself. Take the gravity of the offense, hang him the same day. That is the meaning of your argument, have you realized?
It may fix on Tuesday, I will try to satisfy.
Madam Devi, we are not very happy. Every day you say the same thing.
Yes, that's it. But since he was,
But once you are out of the court, you forget about the matter.
that's it. I try my best.
Next time when the matter is listed, when you enter the court, you again remember everything. And you remember to the extent that you repeat the same thing again and again. And at the end of the day, I'll prepare, we'll give you more time. How many more times?
This
Will
will be the
impose
last.
the adjournment cost then?
No, no. On Tuesday, I will try not.
You're not fair to the court. Have you realized?
Because there is nothing in the act or rule that this is the lordship ground on which the commandant can exercise dictation. It is,
Very well.
this is right. But otherwise, the proceeding, some proceeding is curtailed, but.
Very well.
Lordship.
Thank you. So we conclude the hearing then. You don't have to say anything.
One more substantive given. Right.
So your submission is, if the statute does not provide, we are not required to follow any other principle of law. Okay, we'll take note of that submission. What is he asking before the court? Give me a proper opportunity. That's all. And you are every day adamant, no, whatever is given to you is good enough for you because you are a Havildar. Had you been a major, we'd have given you much more better treatment. But as you are a Havildar, we are not in that.
He was given an opportunity because evidence were recorded and he was given, Lordship provided the opportunity to, and he has accepted that he has committed a crime. Therefore, on the basis of his admission and on the basis of statement of the eyewitness, he was found guilty. And thereafter, he was also filed appeal also. In appeal also, it is.
So that's a end of your argument then.
No loss. It will fix on Tuesday.
It is argued by MS R. Devi, learned CGC, along with Mr. Padmanabha Chakraborty, the deputy, what? Deputy Commandant, that as because the Sashastra Seema Bal 2000 Act 2007 does not provide for anything further. Therefore, the legal principles which are otherwise acceptable would not be applicable to the Sashastra Seema Bal when exercising the power under the Act.
No, let's say this is.
This is what you are submitting. It is also submitted that the petitioner is given all the opportunity he had admitted, and therefore the procedure adopted is justified. This is your submission.
That's it.
It is also submitted that the commanding officer has the discretion in respect of an official of the rank of Havildar or below to either try him himself in a summary force court, or to send him to the general force court. And because the commandant was of the view that this was an emergent situation, therefore it was thought that there is no necessity to send to a general force court, and that the commandant can to decide the matter himself. The learned counsel to make further submissions on the acceptability of the aforesaid submissions in law. Next, list on so and so. We have noted that the same submission is repeated on every day of the hearing by taking adjournment, that the further questions raised would be looked into and answered. But unfortunately, it's not happening, and the same thing is repeated. Today again, time is sought for to examine the aspects. Adjournment accordingly, time granted, list on so and so. But we are bound to record it because it's happening every day. 27, let's go, 27-4, next.
Obliged.
Item 10,
Yes, what is this?
Yes, Lordship. Lordship, while the impugned order of penalty, your Lordship, is at page 45.
Page number?
45, your Lordship. Third of March, 2017. The penalty, your Lordship, is at page 46. Your Lordship had raised a query about the matter. His pension has been limited to 50% while he was in service. Your Lordship had cited Rule 21 of the pension.
Oh, that matter.
Yes, that
yes.
matter.
My lord, only now we are limited to this section 21 of the pension rule, my lord.
But how can we invoke 21 before a man retires?
Yes, my lord,
21 is post-retirement.
post-retirement. He was in verge of retirement.
A wiser way out would have been to wait with this proceeding for a few more days, allow
Few
the
more
man to
days.
retire.
Not even a month.
And then convert it to a proceeding under Rule 21 and pass any order you feel like.
My lord. Now the thing is that, my lord, we have passed it. Now, my lord. Yes, there is a lacuna in this, our speaking order.
Then what will you do? At the best, we can do one thing. We can set aside the order and allow you to continue with the proceeding as per law.
My lord.
That is
My lord, there,
as per law.
my lord, the thing is that there is a 4-year bar.
Where is it? Are you sure?
Yes, my lord. If you go by 21,
21B and 21C.
Do you read it the same way? You are trying to submit.
B3, my lord. Explanation. No such judicial proceeding if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be
Wait, where do you get it?
21C, my lord.
21?
C, my lord, C.
Is 21C applicable?
No such judicial proceeding if not instituted while the officer was in service, whether before his retirement or during.
Mr.
his-
Dhor, please read the whole rule carefully.
My lord.
I think it is in your favor.
My lord, my lord. No such judicial proceeding if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be instituted.
Read the first one. Governor of Assam reserves to himself the right to withholding and withdrawing a pension on anybody, whether so and so. If in a departmental or judicial proceeding, pensioner is found guilty. This is the first one.
My lord,
Very well.
my lord.
A, such departmental proceeding, if instituted while in service before his retirement or otherwise, shall, after final retirement, be deemed to a proceeding under 21.
My lord.
So the day he he retires, it is a legal fiction created that from henceforth, it will not be a proceeding under Rule 9, but it will be a proceeding under Rule 21.
21.
Fine. Now read B.
B, my lord.
Mhm.
Such departmental proceeding, if not instituted,
What is the relevance of the expression if not instituted?
if not instituted while the officer was in service.
What is the meaning of the expression if not instituted? What do you understand by it?
My lord,
In those cases where the man retires, but the proceeding was not initiated,
initiated,
that means if not instituted.
instituted.
So subclause B will be applicable to only those people against who retires, but no proceeding is there.
But we had a proceeding.
Then how B is applicable?
Yes, B is not applicable, my lord.
Then come to C. You are relying heavily on C.
No such judicial proceeding, if not instituted.
again.
Not instituted,
Again, if not instituted, C is also not applicable.
applicable.
Then what is applicable? A is applicable.
Such different proceeding, if instituted while the officer was in service,
A is applicable.
whether before. his
B and C are
retirement
not
or his
applicable.
Re-employment shall, yes, my lord. Those to B and C is not applicable.
So moment we set aside, allow you to continue the proceeding as this is a technically fallacious order.
My lord,
You continue the proceeding.
my lord will dispose of the matter, my lord. It will be-
I think that's a law.
That's a
You
law.
cannot look it in any other
No,
way.
my lord. Even I will also not go into it, my lord. Because there is a lacuna in our order, my lord, because we should not have, while he was in service.
Heard Mr. M. Sharma, learned counsel for the petitioner, also heard Mr. A. Dhor,
R for my lord.
sorry, R. Dhor, the additional sitting and advocate for the state of Assam, for the respondents in the state of Assam. The petitioner who was the petitioner was serving as in what post?
Yes, Your Lordship. Executive superintendent engineer, Your Lordship.
Was serving as an
Yes,
as a superintending engineer
yes.
with the respondent Public Works Department. When he was issued a show cause notice,
Dated 4/7/2015.
show cause notice dated 4/7/2015.
Yes,
Comma, while he was in service, comma, under Rule 9 of the Assam Service Discipline and Appeal Rules 1964, read with Article 311 of the Constitution of India, requiring him to show cause as to why penalties prescribed under Rule 7 of the Rules of 1964 shall not be imposed on the petitioner in respect of the two charges that are provided in the show cause notice itself. The petitioner submitted his reply to the show cause notice as per his
replied.
replied as per his reply dated 24/7/2015.
Yes,
The proceeding initiated against the petitioner resulted in the order dated 3/3/2017
yes.
of the Secretary to the Government of Assam in the Public Works Department. The relevant provisions of the order passed in the disciplinary proceeding against a petitioner dated 3/3/2017 is extracted as below. It is 4602 DDO. A reading of the afore extracted provision of the order dated 3/3/2017 makes it discernible that as per the meeting of the Public Accounts Committee of the Assam Legislative Assembly held on 23/9/2016, there was a decision to reinstate the petitioner in his service as superintending engineer and to recover the remaining amount during his service period. Full stop. Accordingly, by the state order, the petitioner was reinstated as superintending engineer PWRD upon revocation of the order of suspension dated 18/6/2015. But certain penalties were imposed. One of the penalty imposed upon the petitioner by the order of 3/3/2017 is that the period of suspension shall be treated to be duty only for the purpose of pensionary purpose, and the salary for the suspended period shall be limited to the subsistence allowance already paid to the petitioner. A further penalty is imposed that the whole of his DCRG, which is understood to be a pensionary benefit, is to be recovered and his pension be limited to 50% of his net pension. Full stop. Being agreed by the order of 3/3/2017, the present writ petition is instituted. It is informed to the court that the tenure of service of the petitioner upon superannuation came to an end on
31/3/2017, the same month.
31/3/2017.
Yes.
Full stop. We have noticed that the order of punishment is dated 3/3/2017. We have particularly noticed that the dominant penalty imposed upon the petitioner is that the whole of his DCRG is to be recovered and that his pension would be limited to 50% of his net pension. Full stop. In other words, the order of penalty is in the nature of a penalty by which the pensionary benefits which the petitioner is otherwise would have been entitled had been interfered to a certain extent. We have already noticed that as per the show cause notice dated 4/7/2015.
Yes.
The petitioner was asked to show cause as to why penalties prescribed under Rule 7 of the Assam Services Pension Rule 1964 should not be imposed upon the petitioner. 64 rules from Assam. 64 discipline. Disciplinary rule from. Rule 7 of the Assam Services Discipline and Appeal Rules is extracted as below. A reading of Rule 7 makes it discernible that one of the punishments that can be imposed is a recovery from the pay of the whole or part of any pecuniary loss that may have been caused by a government servant through negligence or breach of orders. Hey, বেলেগ কিতাপ নাই নেকি? This book is very difficult to read.
If I may read your lordship.
Services manual বুলি এখন আছে, সেইখন। এইটো কোট কৰিছে নেকি? নাই কৰা। Rule 7 is extracted as zero. কৰিছো না? The provisions of Rule 7, Mr. Sharma, be comfortable. Rule 7(3) would be that one of the punishment that can be meted to a government servant upon a disciplinary proceeding being held is to recover the loss caused to the government from his pay, either in whole or in part. In the instant case, although the order impugned dated 3/3/2017 is not very clear, but it has to be understood that the whole of the DCRG of the petitioner to be recovered and the pension be limited to 50% of his net pension is in furtherance of the requirement of the disciplinary authority to recover the pecuniary loss that the petitioner may have caused in connection with the charges against him in the disciplinary proceeding. Recovery of the loss caused to the government by a government servant related to the charges in a disciplinary proceeding under Rule 7(3) can be recovered from the salary and allowances. But Rule 7 nowhere provides that such recovery can also be made from otherwise the pensionary benefits that the government servant would be entitled upon his retirement. The concept of DCRG and pension are definitely related to the pensionary benefits and are in no way related to the pay and salary of a government servant during his service tenure. But again, Rule 21 of the Assam Services Pension Rules 1969 do provide for recovery from the pensionary benefits of a government employee after his retirement. But such recovery from the pensionary benefits would have to be under Rule 21 of the Assam Service Pension Rules 1969. And it cannot be understood or construed that such recovery from the pension would be under Rule 7(3) of the Assam Services Discipline and Pension Rules 1964. Accordingly, as the impugned order dated 3/3/2017 of the Secretary of the Government of Assam in the Public Works Roads Department is in excess of the jurisdiction to order for recovery from the pensionary benefits of the petitioner in a disciplinary proceeding where the order had been passed during the tenure of service, sentence could start with this. So we are review that the same would be unsustainable in law. Accordingly, the order dated 3/3/2017 is set aside on the technical reason as indicated above, that recovery cannot be ordered during the tenure of the service of a government employee from the pensionary services pursuant to a disciplinary proceeding under Rule 9 of the Assam Service Disciplinary Appeal Rules 1964. But as the interference is made on a technical ground, we are of the view that the ends of justice would require that a proceeding that was initiated under Rule 9 of the Assam Services Disciplinary Appeal Rules 1964 by the show-cause notice dated 4 in 2015 should be brought to its logical end by following the due procedure of law. As the petitioner had in the meantime retired from service on 31/3/2017, it has to be understood that the said proceeding would now have to be continued under Rule 21 of the Assam Services Pension Rule 1969. An issue had been raised by the petitioner that it is beyond 4 years that the petitioner had retired from service in the meantime, and therefore the proceeding cannot be continued under Rule 21. Rule 21 of the Service Pension Rule is extracted as below. A reading of the provisions of Rule 21A of the Assam Services Pension Rules 1969 makes it discernible that in the event the Governor of Assam would like to reserve to himself the right of withholding or withdrawing a pension or any part of it, if in a departmental or judicial proceeding, a pensioner is found guilty of grave misconduct or negligence during the period of service, such departmental proceeding, if instituted while the officer was in service,
Whether before his retirement.
please don't interfere, shall, after the final retirement of the officer, be deemed to be a proceeding under Rule 21A and shall be continued and concluded by the authority by which the proceeding was initiated in the same manner as if the officer had continued in service. In other words, under Rule 21A of the Assam Services Pension Rules 1969, there is no such embargo as regards the period that may have elapsed from the date when a government servant had retired from service. All that Rule 21A provides is a legal fiction that if a departmental proceeding had been initiated but could not be concluded, and in the meantime the government officer retires from service, there is a deeming provision that the said proceeding henceforth from the date of retirement would be a proceeding under Rule 21A of the Assam Services Pension Rule 1969, and it would be continued by the disciplinary authority who had instituted the disciplinary proceeding and bring an end to the said proceeding as if the government servant had not retired from service. But on the But on the other hand, Rule 21B provides that if such departmental proceeding contemplated under Rule 21 was not instituted while the officer was in service, in such event, as per the provisions of Rule 21B small Roman 2, it shall not be instituted in respect of any event which took place more than 4 years before such institution. The embargo of 4 years for instituting a disciplinary proceeding after retirement would be applicable only in such cases where the disciplinary proceeding had not been instituted. But on facts, if the disciplinary proceeding had been instituted, it would be covered by the provisions of Rule 21A. That is, there would be a legal fiction in favor of the legal fiction that it would be deemed that the disciplinary proceeding would now be converted to a proceeding under Rule 21A. Similarly, the provisions of Rule 21C that such judicial proceeding also cannot be instituted in respect of a cause of action which arose or an event which took place more than 4 years before such institution would also be inapplicable in case of the petitioner, in as much as the provisions of Rule 21C is also circumscribed to the condition precedent that if the disciplinary proceeding was not instituted at the time of retirement. In an instant case, as the disciplinary proceeding had already been instituted, and it is not a case that it was not instituted at the time of retirement of the petitioner on 31/3/2017, we are unable to accept the contention raised by the petitioner that the proceeding cannot be continued any further, as because it is more than 4 years since the petitioner had retired from service. Accordingly, while setting aside the order dated 3/3/2017, the respondent authority, disciplinary authority, is allowed to continue with the proceeding and bring the same to its logical end as per law by as per law, on an understanding that Rule 21A is applicable in the instant case, and the initial disciplinary proceeding by the show cause notice dated 4/2015 is now converted to a proceeding under Rule 21A.
If your lordship sets aside the impugned order, at least till today, as of today's date, your lordship, for 6 years, the arrears of the 50% of the pension, since they have not.
They cannot do anything. If any deduction from the pension benefits had been made
Or in this
till date, and then no further, accordingly, as the order dated 3/3/2017 had been interfered, no such deduction from the pension benefit from the petitioner shall be made until any such reason order that may be passed in continuation of the disciplinary proceeding. Whatever deduction had been made till date shall be subject to any such reason order that may be passed in the disciplinary proceeding. And if the order in the disciplinary proceeding is in favor of the petitioner, the deducted amount shall be refunded back to the petitioner.
My one submission, your lordship, subject to your lordship's.
Don't have to be so humble.
No. In fact, since your lordship had adjudicated on the order of penalty, so as of today, there is no order of penalty.
No penalty. So therefore, they cannot
So
deduct.
now I am entitled to the arrears of my pension. 50% of the pension since I retired 6
No,
years.
no. From today, you'll get your regular pension till they pass any order.
And
And whatever was already deducted,
yes,
that will be subject to what order they pass. If the order is in your favor, you'll get back everything.
but your lordship had turned back the clock before,
Not turn back. We
On-
stop the clock.
yes, on 2/3/2017.
Now, we have not turned back.
Yes,
We-
your lordship had
We have, Mr.
Stop.
Sharma, we have stopped the clock.
on second of March 17,
We have stopped the clock
Yes.
as on, what is today's date?
2nd of March 2017,
No, no. We have stopped the clock as
Today.
on today, what is today's date?
30th,
30.
30th of
Yeah.
March.
Now, as of 30 March 2023, we have stopped the clock.
Yes,
And if the further order to be passed is against you, they'll continue with any kind of deduction.
yes,
And if the further order is in your favor,
yes.
they'll
Then-
refund you all the amount that
Yes,
has been taken.
But since your lordship had stopped the clock today, subject to the fact that the earlier order penalty has gone now, since your lordship had interfered of recovery of the pension.
Mr. Sharma raises an issue that as the orders had been interfered, therefore, all the amount that had been deducted from the pensionary benefit of petitioner should be refunded. We are in disagreement with the said contention for the reason that the interference is on a technical ground, giving liberty to continue with the proceeding as per the law. And but however, it is clarified that if eventually the order to be passed in the dispute proceeding would be in favor of the petitioner, he would be refunded the amount that had already been deducted. And if it is against him, the provisions of the order to be passed shall prevail
Noted.
on the in respect of the amount that had already been deducted.
Timing at 4.
Forest village, we are unable to understand
My lord, I
where
think-
it comes from.
I think well, we can take a clue from Forest Rights Act 2006. There is a definition well, of
I know,
forest village,
but that is a much more subsequent.
much more substantial.
And plus it is circumscribed. Plus it is an entitlement to a very particular nature of persons, not for everybody.
Exactly. Even my lord, 2006 Act also says for forestry operations.
And that is, but
So
even under that act also you don't get because you have to meet the
requirement of
requirements of that act.
exactly 3 generations, 25 years each, which the petitioner.
And this is given to a different class of people who all along have been living in forests.
They were dependent on forest. These
Dependent,
people were
not only dependent, basically living in the forest only.
Exactly.
There are some
tribes or forest.
tribes, some communities in Assam
True, man.
who have all along been living in forest.
True,
Not that somebody from outside then goes starts living there.
Exactly. There is a case, my lord, they claim to be erosion affected, so they have entered into, which is not permissible, my lord. And Forest Conservation Act Section 2
So-
also bars.
If erosion is connected with these people, the forest will also be eroded after some
Exactly,
years.
exactly. So the prayer made, it cannot be.
Your lordships, one of the deeds of 1987 AIR.
Mr. Borgoya, I think you have concluded your argument.
Lordships, argument complete, one judgment is similar facts, lordship. Here is the case, 1980 Act will not apply. We have land provided to the petitioner in 1975.
No, which paragraph you were relying on?
Your lordship, from paragraph 4, lordship. Paragraph 4, 5.
No, they
These
cannot
are
be you are
the
relying on
exactly
the whole.
similar on their lordship.
No.
Notice,
Mr. Borgoya,
lordship.
what is the ratio of this judgment and where in which
Ratio
paragraph
of
it is there?
Similarly, these people are provided land and subsequently without issuing any notice directed to.
That is something different.
Eviction lordships.
That is something different.
And
Here is a
here is
case,
the
my
case,
lord.
lordships.
Petitioners were never settled with this land matter. They
No.
claim there was a process, but process was abandoned by government. That
Yeah.
should be concluded now. Here, my lord, this case.
In this case.
In
huh?
this case, they say there was a
Something
process.
different.
So as of today, my lord, the law applicable is directly against them, my lord. There cannot be any settlement inside a forest.
Plus, it is a judgment of 1987.
87,
The Forest Conservation Act it was
1980.
was not taken note of. It's a
Exactly.
per inferium judgment.
Exactly.
And here is the, my learned friend says, we are not pausing, but person given 1975, lordship, 34, 1976. We are residing there within that village. And not only us, other villagers are also there, lordship, prior to our possession, prior to providing possession to us.
Very well.
And there,
Very well.
my humble submission, let the dear
Mr. Borgohain,
lordship. My learned friend
the
also had
kind of
the
arguments that are coming,
lordship.
we are tempted to ask a question. Can the earth be sold by somebody? Is there a buyer somewhere where the earth can be sold? No,
No,
earth has to be protected.
certainly.
Environment has to be
Yes,
protected.
Certainly, lordship. But we are abiding all the rules, forest rules.
These
also
few
not-
people are nothing when the question of environment and the sustainability of the earth comes into question.
If they violate lordship, and certainly authority has the power to evict us. Till then, we will be allowed.
Change কৰিবা নেকি? এইটো দীঘল হ'ব নহয়। মইতো আধা দীঘল কৰিয়ে গ'ল। এই মাটি কাৰণ অলপমান আৰু দীঘল হ'ব না। আৰম্ভ কৰি দিয়া। Third,
One last submission, my lord. The forest now comes under concurrent list after 72nd amendment, my lord. So any law of the central government will prevail over every law of state government, my lord. So that
no, but
forest.
the Assam forest regulation is a central law.
It's
not
a central
state
law.
It's
That's
not
a central
state
law. I'm saying about the rules of forest village forest rule. So that may not have any impact today, madam, because otherwise the law, Forest Conservation Act, Forest Right Act goes directly against the petitioner. So they cannot take recourse to that rules purportedly framed under, my lord, we don't know when it was framed under the 1891 regulations, madam. Forest being a concurrently subject, my lord, state law has
We have to deal with this concept, forest village
my lord.
in detail.
As my lord, we have already seen, my lord, regulation 29 and 30 speaks about, my lord.
No, that is a village forest.
Exactly. So there is nothing called forest
And
village.
village forest, if you read the provisions, it is explicit and clear that these are villages outside the notified forest areas
Exactly.
where some forest exists. That existing forest in or within the in or around the village is now notified under section 29.
Yes.
That this will be used by the community of the village.
Exactly.
That is the only purpose.
That is the only
That is in furtherance that even forest exists beyond the notified forest areas, conserve that also. That is the purpose of Rule
Exactly.
29. Not that Rule 29 gives you the power to destroy the forest and
Exactly.
start a village inside it.
Exactly. No, certainly not.
It's a totally different provision.
My senior's name may be in the questions.
Heard Mr. H.R.A. Chaudhary, learned senior counsel for the petitioner. Also heard but in 45 minutes, Mr. Goswami will not be able to complete it. I'm quite sure.
My lord,
This judgment will take much longer
my lord,
time.
we
It
can
is
first order that.
CAB, it will be better.
CAV, like,
But
My lord, we dictate
date-
sometime else, my lord.
another
Hmm.
date may be given for delivery.
এখন বেঞ্চ অকল এটা মেথৰ কাৰণে পাৰি নেকি 1 ঘণ্টাৰ কাৰণে only for this matter. এতিয়া দি দিওঁ তেতিয়াহে বাকীখিনি দিব পাৰিম।
I'm appearing for all the respondents.
I also heard Mr. P.N. Goswami, learned additional advocate general for the state of Assam for the respondents. The 57 writ petitioners have instituted the writ petition with the following prayer. Quote prayer to page 25. A reading of the prayer makes it discernible that the writ petitioners seek for a direction to the respondents in the Forest Department of the Government of Assam. As well as the Deputy Commissioner and Deputy Commissioner Karimganj and Circle Officer Patharkandi Revenue Circle, to take necessary steps to enter the names of the petitioners in the Jamabandi register in respect of Old Solamona Boro Sobri Forest Village. In terms of the letter number FGI/18/0/74/3069 dated 6/11/1974. Of the then Conservator of Forest Assam, namely M.A. Islam. This person is Mr. Goswami. This person is no more. Is he alive or?
Cannot precisely say, but it is of 74.
Maybe.
Because PCCF.
Is he?
So PCCF is a senior post.
Sorry.
PCCF is a senior post. He had to be a old man by that time. 74.
So unlikely to be alive.
Unlikely.
Maybe he would have passed some of this. Maybe. As well as the order dated, office order number 262 dated 31/12/1975 of the Divisional Forest Officer, Kachar Division, Silchar. The letter of the Conservator of Forest dated 6/11/1974 is extracted as below. The order of the Divisional Forest Officer, Kachar Division, Silchar, dated 31/12/1975 is also extracted as below. The petitioners in their prayer also seeks for a direction to restrain the respondents from evicting the petitioners from their respective land without following the due process of law, or further as to why or further to issue a direction to the respondents to allow the petitioners to enjoy their continuous possession of their land at Old Solamona Boro Sobri Forest Village without any interference. The reading of their subsequent prayers makes it discernible that The purpose of the writ petition is to issue a direction in favor of the petitioners that their occupation of the land at Old Solomona Borosobri Forest Village be declared to be permanent in nature, so that their enjoyment of the land continues. Change করা বহুত হবো নহলে এখন দিগদারি হয় মাথা কোন আছে নাহে কিয় হ্যাঁ মাটি কি লিখিলো and that sentence complete করিবা last sentence complete করা the word is not coming, one particular word is there to describe this permanently.
Permanent.
No, this occupation they want it to be made permanent. That
They want their names to be
no,
registered.
not on the second part of the prayer.
Yes.
We are on the second part, not the first part.
Yes, ma'am.
First part is names. Second part is to allow the enjoy the continuous
In
possession of
perpetuity.
land without any interference.
In perpetuity, madam.
And to allow them to enjoy the land in perpetuity. This is the word that
Rule also clearly said till their satisfaction or those written in that.
Mr. Borbore, this will be a huge judgment, don't worry, we'll include
Right.
everything.
That rule says lost it.
This is not a 2-paragraph judgment, don't
Yes.
worry, we'll include everything. A reading of the letter dated 6/11/1974 from the Conservator of Forest, Assam, makes it discernible that about 100 to 200 bighas of land are available without tree forests. And such forest land were earlier encroached by the people belonging to the Rang Riang community. And the forest department had undertaken the process under the law to evict the Rang Riang people from the forest land. So now, in order to protect the forest land, that the Rang Riang people do not come back and re-encroach the land again, the Conservator of Forest deemed it appropriate that 60 landless people from outside, as certified by the subdivisional officer Karimganj, may be allotted the land after proper survey by giving 5 bighas of Rupit land and 2 bighas of Bari land to such 65 outsider landless people. the entire approach of the conservator of Forest Assam is nothing but mischievous.
That then, madam. That then conservative.
Whosoever it is nothing but mischievous. If certain indigenous tribal people had entered and occupied some private, some forest land, and the authorities deemed it appropriate that such indigenous people should be evicted from the forest land so as to protect land, and the eviction process was carried out and the encroachers removed. But to ensure that the same indigenous forest people do not come back and encroach upon the forest land, therefore the land should be allotted to some outsider people comprising of 66 landless people. Where is the list of the landless people? The list of the 66 landless people to whom?
Page 20,
40, madam.
47, I think.
page 29 also, Lordship.
If possible, give a soft copy of this one. Are available at page 47 of the writ petition and are extracted as below. No material is available to form any view as to who are these outside people, from where they have come from, and why they have been allotted land inside the forest. In a reading of the order of the Divisional Forest Officer, Kachar Forest, Kachar Division Silchar, dated 31/12/1975. Provides that subject to abiding of the existing forest village rules, the one Moinul Haq and 55 others as per the aforementioned enclosed list are handed over possession of the land upon demarcation as per the order of the conservator of forest, by taking a written objection that they will abide by the rules and regulations in force, and further that the names of the said persons should be entered in the Jamabandi register maintained for the purpose. Stop. A further reading of the letter of the Conservative Forest dated 6/11/1974 makes it discernible that some further forest land in Dhubri district are also sought to be allotted in such mischievous manner, but it is not done for the present as per the said letter, meaning thereby that intention was to destroy the forest land in the same manner in other districts also. Upon considering the prayer made in the writ petition, we have heard the learned senior counsel for the petitioner, Mr. H.R.A. Chaudhary, on the right that the present petitioners may have to have their names entered in the Jamabandi maintained for the purpose, and also for a direction that their occupation at the land should be made permanent in nature, and so that they can enjoy it in perpetuity. Mr. H.R.A. Chaudhary, when Senior Counsel for the petitioner refers to the chapter 7 of the rules for establishment and control of forest villages, purportedly made under section 72 bracket E, 74 and 75 of the Assam Forest Regulation 1891. Chapter 7, comprising of the rules for establishment of control of forest villages, is extracted as below. But it's a huge one. Good. Type মাৰিব লাগিব। এৰি দিব, দিয়ে দিবা নেকি তাইক? ব্যৱসায় কৰিব। We have examined the provisions of refers to the rule here. By referring to the rules for establishment and control of forest villages, Mr. H.R.A. Chaudhary and Senior Counsel submits that the petitioners have been put into possession inside the reserve forest land under the said rules, and that under the rules in question, they have a legal right of their names being entered in the Jamabandi, as well as that some kind of heritable right is also provided within the rules itself. That is submission. And therefore, the petitioners being the second generation of the persons, and most of the petitioners being the second generation of the persons who were put into possession of inside the forest land by the, as per the letter dated 6/11/1974, have a permanent, heritable, and a legal right in perpetuity to occupy the forest lands, and also to regularize the process by having their names entered in the Jamabandi. On the submission of the learned senior counsel, we have noticed two aspects that are to be looked into. The first aspect would be what will be the implication of the rules for the establishment and control of forest villages purportedly made under section 72E, 74 and 75 of the Assam Forest Regulation 1891. And further, the relevance of entering the names of the petitioners in the Jamabandi, and what under the law is the concept of a Jamabandi. as the rules for establishment and control of forest villages had been framed under section 72E, 74 and 75 of the Assam Forest Regulation 1891, comma, we required Mr. P. N. Goswami, Learned Additional Advocate General for the state of Assam, appearing for the respondents, to refer to any relevant provision under the Assam Forest Regulation 1881, which may contain the provision of establishing a forest village. Full stop. As per the petitioners, the concept of forest village is given to be understood to mean that it will be a village which would be inhabited by people and would be located inside the notified reserve forests. Mr. P. N. Goswami, Learned Additional Advocate General, for the purpose, refers to section 29 of the Assam Forest Regulation 1891, which provides for constitution of one inverted comma village forests. And that of rule, the section 30, which is the rule-making power for framing of rules for the village forests. Apart from the aforesaid provision, Mr. P. N. Goswami, Learned Additional Advocate General, is candid enough to state that there is no further provision in the Assam Forest Regulation 1881 providing for establishing any forest village. Accordingly, we examine as to whether the concept village forest as provided in section 29 and a forest village as provided in the rules for establishment and control of forest village are one and the same in its meaning and purport. Reading of clause of rule 1 of the rules for the establishment and control of forest villages provides that forest villages may be established within the limits of any reserved forest on sites and locations of which will be approved by the conservator of forest in writing. Rule 1 makes it explicit that the location of a forest village would be within the limits of any reserved forest. On the other hand, section 29 of the Assam Forest Regulation 1891 provides that the state government may, by notification in the official gazette, constitute any land at the disposal of the government a village forest for the benefit of any village community or group of village communities, and may in the like manner vary or cancel such notification. Full stop. Section 29 of the Assam Forest Regulation 1891 makes it explicit that the location of the village forest, one inverted comma, to be constituted under section 29 of the Assam Forest Regulation 1891 would be over any land at the disposal of the government. Section 238 of the Assam Forest Regulation 1891 defines one inverted comma, land at the disposal of the government, inverted commas, yes, to mean land in respect of which no person has acquired a permanent, heritable, and transferable right of use and occupancy under any law for the time being in force, or any land created by grant or lease made or continued on behalf of the government, not being land vested in the government for the purpose of central government. Section 29 and 28 are extracted as below. Section 28 defines land at the disposal of the government in negative terms. That is, all such other land other than the land over which any person may have acquired a permanent, heritable, transferable right of use and occupancy under any law, or any right created by grant or lease, or continued by or on behalf of the government, not being land vested in the government for the purpose of the central government. A reading of rule section 2(a) makes it discernible that the residual land at the disposal of the government beyond the land over which permanent, heritable, transferable right of use and occupancy had been granted, or any land created by grant or lease made or continued by on behalf of the government, and not being land vested in the government for the purpose of the central government, would be land at the disposal of the government. In other words, we are required to interpret the provisions of section 2(8) of the Assam Land Regulation 1891 as to whether the residual or balance of the land would mean all such land in the state of Assam over which no permanent, heritable, and transferable right of use and occupancy had been granted, or any right created by grant or lease made or continued by or on behalf of the government, not being land vested in the government for the purpose of central government. Or the residual or the balance land would have to be understood to have to be in the context of land over which a permanent heritable transferable right of use and occupancy under any law or any right created by grant or lease made or continued by or on behalf of the government, not being land vested in the government for the purpose of central government. Line to I lose track of the beginning of the sentence. এটা word এটা কোৱা নাছিলো আৰু এটা related to or কিবা এটা এটা কোৱা নাই নেকি না না গোটেই সেন্টেন্স পঢ়া আছে গোটেই সেন্টেন্স পঢ়া আছে সেইটোৱে তাৰপিছত to be in the context of the what is to be in the context of this land. That's all. Because if we understood to be all the balanced land, everything is included. The river Brahmaputra is included. Your only thing, it must not be given any kind of a heritable right. Settlement should not be given and should not be granted for the central government.
Exactly.
Other than that, it will be the balance of the land, or understand will be balance will be in the context of this land which can be allotted or granted to limited to that extent, or it means any balanced land in the state of Assam, nook and corner, wherever it is. Which meaning will be correct? Because if it means any kind of land, it will include the forest land also.
The forest land is different, it has been different.
Land at the disposal of the government, Mr.
Land at the disposal of the government.
This is a negatively worded.
No
meaning.
person has acquired a permanent
So
heritable
if
transfer.
somebody has acquired any heritable right, if somebody is,
it's like
a grant is made, other than these two category, these two kind of land, it is everything else.
Yes.
Everything else may include forest, everything may include the river Brahmaputra, everything may include all kind of natural things that are available in Assam. Or this balance is only in the context of land which can also be allotted, but not allotted. Have you got the difference?
I got it, my lord. My contention would be, my lord, the second part that my lord has said, my lord, will be
It
more.
has to be in the context of that land which otherwise can be allotted.
Because, my lord, section 29 nowhere says including forest land.
No.
Section
It
21 is
may not
silent about
say,
forest.
it may not
says,
say. It says at the land of the disposal.
so,
So you have to interpret to it now.
to it,
Okay, fine.
more particularly, my lord, there is no reference of forest land in section
May
29.
not be,
So,
may not be, but if it says at the disposal of the government and the land at the disposal of the government also includes forest, it can be there also.
yes,
Therefore, we are making the endeavor to find out whether the balance residual land at the disposal means only those category of lands which can also be allotted, or it means any kind of land. Any kind of land will include the Brahmaputra also.
Exactly.
Everything is at the disposal of the government.
Exactly.
But for the context of 2.8, which meaning will be more applicable? Every inch of the balance of the land, or only those lands which can also be subjected to allotment but not allotted?
I think, my lord, the second proposition will. be
Possibly.
for-
That's why that is what we are trying to look into. If you go by the first proposition,
Even forest land will also come. my lord.
everything, not only forest,
Everything.
hills, rivers,
Section 8.
rivers, lakes, ponds, everything.
The 2.8A says permanent, heritable and transfer. It's more like. my
So
lord, partition.
therefore, we are putting the question whether it should be in the context of the land that can be allotted.
Exactly.
Continue. Tuesday. 2:45 minutes. Will. এনে আজি লিখি থৈ দিয়ক। List for further delivery of order on Tuesday. Oh. Just.
Who look like a little bit.
Mr. Goswami tried to find out how a negatively worded definition is to be interpreted. Because inclusive definition is very easy to interpret. This is what is there, rest nothing else is there. But when it's a negatively worded definition, other than what is provided is excluded and rest everything else in this world is included. Or the rest of the inclusion also,
May not be exclusive.
no, it to be in the context of the matter.
My lord.
I think it is in the context of the matter, just find it out.
Just
If-
one point, my lord. If we take, my lord, help of T. N. Godapuram's judgment, my lord, to exclude forest from this land, my lord.
No,
It says,
we have to interpret 28(9) now.
yes, my lord.
So you can't go to Godavaran. Godavaran cannot give a different interpretation to the Assam forest regulation.
No, my lord, but Godapuram defines forest land, my lord,
Maybe,
in the context of.
maybe.
forest.
We are not on forest land. We are on the read 29. 29 doesn't say anything of forest.
Exactly. That is.
It says land at the disposal of the government. And what is land at the disposal of the government? 2.8.
My lord.
So we have to find out whether forest land is included in 2.8 or it is not included in 2.8.
Exactly.
If it is included in 2.8, government can create a village forest there also.
Exactly.
But if it is not included, it cannot be done.
My argument would be not included, my lord.
Hmm.
I'll.
So just
on that
try
knowledge,
to find out that
negative-
judgment,
Yes, ma'am.
how a negatively
Use what
uh,
is.
worded definition is to be interpreted. And whether the residual aspects is unlimited or it is to the context. I think you'll get it somewhere.
Obliged.